Urgent to mention a lordship. Fresh habeas corpus lordship. Fresh habeas corpus matter lordship.
Pardon to make a mention, my lord. Item number 15 on behalf of Mr. Lalitchandra Mishra. Due to sad demise of his mother, he is unable to appear today. Kindly taken up this matter after 2 weeks.
Yes.
And also, my lord, item 30.
When the matter reaches, just make a mention. We'll add them. There is no problem. Yes.
God bless you.
Quickly list item number 1.
May I please proceed?
Yes.
Minor daughter of the victim petitioner has been killed, my lords, by the opposite party number 5 with the cooperation of his father parents matter. I manage FIR laws matter and also written to the SP Bhadra.
That name is Sagar Barik.
Yes, my lord.
And by the way, what is the age of your daughter?
16, my lord.
Have you mentioned anywhere what is the date of birth or any proof of?
It is written in the FIR, my lord. Age of 16 years.
No, aged about 16 years. What is the date of birth? What is the documentary proof to that effect?
The application doesn't say so.
And passed in this year 10th exam, my lord.
It's all right, but
that is not a criteria. Do you think that in a particular age one can appear only HSC, not after that? That is your understanding or what? You mean to say that merely because he has just appeared, he cannot be beyond this particular year? All right. This is a fresh matter, so
yes.
And you also obtained that date of birth certificate.
Yes, yes.
Right. You have received the copy. So take instruction about the matter. This writ petition has been filed by this petitioner is the mother.
Mother.
Petitioner Arati Lota Barik, who is the mother of the victim girl.
Sorry, my lord, it is written date of birth. Date of birth written 7/1/2007.
Likhijandi?
Yes, yes.
Hudi?
FIR. Page 13.
Page 13.
Yes. Last 6 line, man. ମୋ ଝିଅର ଜନ୍ମ ତାରିଖ 7/1/2007.
Okay. With a prayer for rescue of her minor daughter, who is allegedly kidnapped by the respondent number 5, Sagar Bari, with help of his parents, that is respondent number 6, Shadasiv Bari, and respondent number 7, Srimati Minati Lota Bari. Land counsel for the petitioner submitted that the date of birth of the victim is 7/1/2007, and the occurrence in question took place on 29/5/2023, and in connection with the kidnapping of the victim, petitioner lodged the first information report before the inspector in charge of Vasudevpur police station on 1/6/2023, for which Vasudevpur PS case number 315 dated 1/6/2023 was registered under section 363/506/34 of the Indian Penal Code against the respondent number 5, 6, and 7 And even though in the meantime, more than 6 months have already passed, no sincere attempt has been made by the investigating agency to trace out the minor daughter of the petitioner or to arrest the respondents number 5, 6, and 7. Stop. The Learned Counsel for the state has received the copy of the writ petition and seeks some time to obtain instruction. Put up this matter on କେବେ ରଖିବା କୁହନ୍ତୁ? 2 weeks after. 2 weeks after ତ ଛୁଟି ଆସିବ. So it will second week of January we are keeping. Second week of January. The Learned Counsel for the state shall obtain up-to-date entry, up-to-date case diary. So also the steps taken by the investigating officer for rescue of the victim girl. Free copy of the order be handed over to the investigating officer shall remain present on the next date.
My lord, I may pardon. My lord detected कि incidents took place in 29/5.
That is
But
mentioned in the
31/5, man. 29/5 he threatened and 31/5 he kidnapped the man.
Okay. 29/5/23 oblique कर दियो 31/5/23. In the FIR, in the first page formal FIR, it is mentioned.
Yes, 29/5 he threatened.
29/5/2023 oblique 31/5/2023.
Oblige me.
Yes.
My lord, kindly see the order dated 6/11/2023. Item 2. Kindly see the order dated 6/11/2023.
So writ petition, writ appeal also disposed of.
Yes.
My lord.
That order was confirmed, which was passed in the writ petition.
My lord.
And the state has challenged. Okay, Archa. You took time to obtain instruction. What has happened?
Let it be taken up tomorrow when Mr. Das is conducting this.
Okay.
Today there is a setback. Our one AGA expired today. AGA YSP Babu expired today. YSP Babu.
YSP Babu.
It is colleague supplementary as paid for by the Learning Council for the state. List this weekly list to show. So 6, 12. Next.
Item number 3.
Ma'am, please, ma'am. I'm referring to VC. My lord, there is an inadvertent error which has taken place while mentioning the nomenclature of this petition, my lord. I beseech your lordship to direct pass an order to convert the nomenclature to CRLMP, my lord.
No, you file a interim application for conversion of the WPCRL.
My lord, I would happy to oblige, but the situation is extremely urgent. The trial of the case has been protected since last 1.5 years or 2 years. So it may consume another few days. So in exercise
The
of
Learning Council for the petitioner, Mr. GP Lal, appearing to
Mohammed Mushtaq Ansari. My name is Mohammed Mushtaq Ansari, my lord.
Mohammed Mushtaq Ansari submits appearing to virtual High Court, Sambalpur, that he intends to file an interim application for conversion of this WPCRL, the nomenclature of the WPCRL TO2. What is that? CMPL? CRLMP. Put up this matter immediately after the interim application is filed. Yes.
Grateful, my lord.
Item number 4.
Item 4 password.
No, it's a CRLMP of
Yeah, no, my lord, that is actually this honorable court also dispose of similar application, my lord.
What similar application?
My lord, WPCRL 93 of 2022. T. Anita Maji versus State of Orissa.
Your prayer is that immediate steps to be taken to ensure the attendance of the witnesses in the court below for early conclusion of the trial of the cases. Number of cases are there,
Yes, ma'am.
right?
Yes, ma'am.
So how it's a WPCRL? It's a habeas corpus. In what
No,
way it is a habeas corpus?
Also, my lord, I have prayed for release of the petitioner. Release of the petitioner also.
Is he a illegal confined? Somebody has been in judicial custody in connection with a case. If you want bail, you can file the bail application. How it can be a judicial on the basis of some judicial order? If somebody is detained in judicial custody, can it be said to be on a illegal order?
Bail application has been filed, madam.
The learned counsel for the petitioner seeks some time to file an interim application for conversion of this WPCRL to CRLMP. List this matter immediately after the.
If that file may be tagged, madam, that will be clarified, madam.
File koronto age.
A copy should be served
Next.
Copy to be served. Copy with the
The copy of the WPCRL and interim application be served on the learned counsel for the state. Yes, next.
Item 5.
May I please, your lordship? The minor daughter of the present petitioner is kidnapped, your lordship. Last occasion, your lordships directed the IIC Fulbani to take necessary steps to rescue the girl, and directed to the IICs to present to the court what the sorts of inquiry he has made.
So we passed the order on 6/11/23.
Yes, your lordship.
So almost a month has passed. What is the development?
सर विभिन्न खबर पाइकिरि सर आमे नयापल्ली एरिया रे खबर पाइथिलु नयापल्ली एरिया रे मध्य रेड थिला सर आउ तार रिलेटिव तार फ्रेंड्स रो सस्पेक्ट रो फ्रेंड रो रिलेटिव रे मध्य रेड थिला सर पाइलुनी सर आउ तार गोटे सस्पेक्ट रो गोटे इंस्टाग्राम अकाउंट पाइछु सर सेतिरे एडा कैलिफोर्निया हेडक्वार्टर को पठाई दी सर सेतिरे किछि मोबाइल नंबर जेहेतु से लाइन रे अछि सर लिंक अछि से पय टी वेट करछु सर ऑर्डर आसीनी सर सेटा किछि समय देले सर आमे रेस्क्यू कर देबो सर
Give a copy of this report. Have you handed over? You yourself investigating. You are the IAC.
नहीं सर एसआई रंजिता बेहरा सर मो आईसी अछि सर मो 21 9 रे जॉइन कली सर 2023 रे
All right. In persons of the order dated 6/11/2023, Kanak Kumar Maji, Inspector in charge of Town Police Station, Fulbani, present, and he has filed the up-to-date status report regarding the rescue of the victim wherein it is stated that the IO Ranjita Behera, who is the SI of police,
Sir,
is investigating the case with utmost sincerity and honesty, and it is hopeful that the victim would be rescued at any moment, and available of little clue regarding the whereabouts of the victim as well as the accused. Some more time has been sought for rescue of the victim girl. Copy of the status report is taken on record. Of this matter. I see second week of January for the IIC shall remain present on that day to apprise us about the up-to-date development made in the meantime. Free copy of the order be handed over to the Learning Council for this case. Yeah.
Obliging.
Item 6.
Where is that man? And come. I'll say you. Yes, relocating. That is it. ସବୁ ଯାଇକିନି ତଦନ୍ତ କରିକିନି ଦେଖିଲେଣି ସେ ଯୋଉ ଭଡାଟେ ନେଇଛି ଗୋଟେ ଘର 2000 ଟଙ୍କା ଦେଇକିନି ଏଗ୍ରିମେଣ୍ଟ ସେ ଯାହା ହଉ ସେ ପଚରା ପଚରି କରିକିନି ତ ବର୍ତ୍ତମାନ ହଉଛି ତମ ଉପରେ ଡିପେଣ୍ଡ କରୁଛି ତମେ ଯାଇ ତମ ସ୍ୱାମୀଙ୍କ ପାଖରେ ରହିବ କି ନ ରହିବ ଯିବେ ଆଉ ତମେ କଣ ପଚାରୁଥିଲ ସେ ଘର କରଣା ଜିନିଷ ସବୁ ଅଛି ନା ନାହିଁ ଏବେ ଥିଲେ ଘର କରଣା ଜିନିଷ ସିଏ ପୁରୁଷ ଲୋକ ତମେ ସିନା ଗଲେ ଘରଣୀ ଗଲେ ଘର କରଣା ଜିନିଷ ଆସିବ ସବୁ ଠିକ ଠାକ ହବ ଆଉ ସେ ତ ପଡା ଘର ଠିକ କରିଛି ଆଉ ଯାଇକିନି ରହିବ ନା ତାପରେ ଧୀରେ ଧୀରେ ତମ ବୈବାହିକ ଜୀବନକୁ ଆଗକୁ ନବ ହଁ ଆଉ ତମେ ତ ଆଜି ଯିବ ସ୍ୱାମୀଙ୍କ ସାଙ୍ଗରେ ସେ ପୋଲିସ ସବୁ ଯାହା ସୁବିଧା ଅସୁବିଧା ହେଲା ଦେଖିବେ ଯଦି କିଛି ହୁଏ ସେ ହେଲା ହଁ କେସ୍ ଆମେ ତୁଟେଇ ଦଉନୁ କେସ୍ ରଖୁଛୁ ଆମେ ଦେଖିବୁ ସେ ତମକୁ ନେଇକିନି କେମିତି ବ୍ୟବହାର କରୁଛି କେମିତି ସବୁ ଚଳାଚଳି ତମେ ଦି ଜଣ ହଉଛ ତାପରେ ଆମେ ଯାହା ଡିସାଇଡ କରିବୁ ହେଲା
ଆଜ୍ଞା ମ୍ୟାମ୍
ତ ତମ ଦାୟିତ୍ୱରେ ଯେହେତୁ ନେଇକି ଯାଉଛ ସତ୍ୟପାଠ କରୁଛ କୋର୍ଟରେ ଷ୍ଟେଟମେଣ୍ଟ ଦଉଛ ନେଇକି ଠିକ ସେ ରଖିବ କୌଣସି ପ୍ରକାର ଅସୁବିଧା ହବନି ପୋଲିସ ବାବୁ ତାଙ୍କର ଜଣେ ଲେଡି ଅଫିସରଙ୍କୁ ପଚାରି ମଝିରେ ମଝିରେ ଯାଇକି ଦେଖିବେ କୌଣସି ସୁବିଧା ଅସୁବିଧା ହେଲା କୌଣସି ପ୍ରକାର ଯେମିତି ଅସୁବିଧା ହବନି ହେଲା ଭଲରେ ରୁହ ଆମେ ଆଉ ଗୋଟେ ତାରିଖ ଧାର୍ଯ୍ୟ କରୁଛୁ ଏଇଟା what is this prayer in this writ petition ସେ ପିଲାଟି ବର୍ତ୍ତମାନ ଅଛି ଆପଣଙ୍କର ତମ ଇଏ ପିଲାଟିକୁ ନେଇ ଆସିବ ତମେ ଦି ଜଣ ଯାକ
ଆଜ୍ଞା
ହେଲା ତମ ବାପା ମା ପାଖରେ ଅଛନ୍ତି ନା
ଏକ୍ସକ୍ୟୁଜ ମି ସାର୍ ପିଲା ଚାହୁଁନି ଆମ ପାଖକୁ ଆସିବା ପାଇଁ ପିତା ମାତାଙ୍କ ପାଖରେ ରହିବା ପାଇଁ ଚାହୁଁଛି ଆଜ୍ଞା ଛୋଟ ପିଲାଟି ପିତା ମାତାଙ୍କ ସେବା କରି ଆସିଛନ୍ତି ପ୍ରଥମରୁ ବାପା ମା କରି
କାଇଁ ତା
ଆସୁଛନ୍ତି
ମା କଣ ଅସୁବିଧା କଲା ସେ ବା ଜନ୍ମ
ଆଜ୍ଞା
ଦେଇଛି
ଜନ୍ମ କରି ଆଜ୍ଞା କ୍ଷୀର ଟୋପାଟେ ଦେଇନାହାନ୍ତି ଛୁଆ ଛାଡିକି ଆଜ୍ଞା ସେ ଚାଲି ଯାଇଥିଲେ
ପିଲାକୁ ଆଣିକିନି ମାଙ୍କ ପାଖରେ ଛାଡିଲେ ସିନା ଯାହା ସ୍ନେହ ଶ୍ରଦ୍ଧା ପାଇବ ସିଏ ଦେଖିବ ତାର ମେନ୍ ଦାୟିତ୍ଵ ତାଙ୍କର ଆଉ ତମ ବାପା ମାଙ୍କ ପାଖରେ କଣ କେମିତି ନେଇକି ଛାଡି ଦଉଛ
ଆଜ୍ଞା ସେଇ ଛୋଟ
ଆମେ
ପିଲା
ସେଠି ଗୋଟେ ଟେମ୍ପୋରାରୀ ଆରେଞ୍ଜମେଣ୍ଟ ହେଇଥିଲା ସେ ତମ ଭିତରେ ବିବାଦ ଥିଲା ବର୍ତ୍ତମାନ ତମେ ଦି ଜଣ ଯେହେତୁ ଏକାଠି ରହିବ ପିଲା ଆଣିକିନି ରଖ ତମ ପାଖରେ
ଆଜ୍ଞା ସାର୍
ହେଲା
ଆଜ୍ଞା
ମାଙ୍କୁ ପାଖରୁ ପିଲାକୁ ଦୂରେଇକିନି ରଖିବନି ନା ତମ ବାପାଙ୍କ ପାଖରୁ ତମ ଦି ଜଣ ଯେମିତି ବଢେଇବ ସେ ପିଲାଙ୍କର ଦାୟିତ୍ୱ ନବ ତାଙ୍କ ପାଠପଢା ତାଙ୍କ ଭବିଷ୍ୟତ ସବୁ ତମ ଆଗରେ ସେ ବୁଢା ବୁଢୀ ଅଛନ୍ତି କାଲି ସକାଳେ ଥିବେ ନଥିବେ
ଆଜ୍ଞା
ହେଲା
4 ବର୍ଷ ପର୍ଯ୍ୟନ୍ତ ଆଜି ସମ୍ଭାଳିକି ଆଜ୍ଞା ଛୁଆକୁ
ହେଲା
ରଖିକି
ସେମାନେ
ମଣିଷ
ସମ୍ଭାଳିଛନ୍ତି
କରିଛି
ଆଗକୁ
ଆଜ୍ଞା
ତମେ ସମ୍ଭାଳ ତମ ସବୁବେଳେ ଅନ୍ୟ ଦାୟିତ୍ୱ ଦିଅନି ତମ ବାପା ମା ଠିକ ଅଛି ସମ୍ଭାଳିଥିଲେ ଭଲ କଥା ମୁଁ ସେମାନେ ବି ଆସିବେ ସେମାନେ ବି ଦେଖିବେ ତା
ସେମାନେ
ସହିତ
ଆଜ୍ଞା
ତମ ଦାୟିତ୍ୱ ରହିଛି ତମେ ବାପା ମା ଯୋଉ ପିଲାଙ୍କୁ ଆଣିଛ ଏ ସଂସାରକୁ ତା ଦାୟିତ୍ୱ ତମର ଆଉ ଅନ୍ୟ ଉପରେ ଛାଡି ଦେଇ ବସି ଯାଉନି ଚୁପଚାପ
ନାଇଁ ସେ
ଆଉ
ଆପତ୍ତିଟା
ସେ
ଆଜ୍ଞା ପିତା ମାତାଙ୍କୁ ଏଇଠିକି ଡକାଯାଉ ଆଜ୍ଞା ମୁଁ
ସେ
ଜାଣିନି
ବାପା ମା ଆସିବେ ତମ ପାଖକୁ ଆସିବେ ବୁଲିବାର କିଛି ନାହିଁ ଏଠି ଆମେ ଦେଖିବାକୁ ଚାହୁଁଛୁ ବର୍ତ୍ତମାନ ତମେ କେମିତି ରହୁଛ ହେଲା ଏକାଠି ଆଗେ ତମେ ଭଲରେ ରୁହ ପିଲାଙ୍କୁ ଆଣିକିନି ତମ ପାଖରେ ରଖ
ଓକେ
ହେଲା
ଓକେ
ହଁ you send some lady police officer sometimes after let us say 2 weeks see that it is we are keeping this matter in January 2nd or 3rd week
Sir.
ଦେଖନ୍ତୁ the inspector in charge of Khandpara police station is present Mr. Jyoti Prakash Swain is present and he has submitted the written instruction dated 3/12/2023 which is taken on record. The petitioner Prabhati Maharana and the opposite party number 1 Satyanarayan Maharana are present. Since as per the report submitted by the IAC, it appears that the opposite party number 1 has taken a house on rent at Kumbharsai, Hondapada, and at the rate of rupees 2,000 per month, and the IAC has himself verified that rented house as per the order of the court and found the minimum facility available there, the petitioner has expressed her willingness to stay in the rented house in the company of the opposite party number 1. Both the petitioner and the opposite party number 1 assured this court that they would live a peaceful, happy marriage life, and the opposite party number 1 further submitted that he will bring their their son, who is now staying with his grandparents, and they would take care of their child. The inspector in charge of Khanpada police station shall send a lady police officer within 15 days to the rented house to see how the couple is how they managing themselves in the rented house with their child. If any complaint is made by either side, that should be properly addressed to by the IAC. Put up this matter in the second week of January 2024. Both petitioner and the opposite party number 1 shall remain present on that day to apprise this court about the development made. In the meantime, free copy of the order be handed over to the Learned Council for the state. So the petitioner shall take the opposite party number 1 shall take the petitioner to the rented house today from the court itself, to which both the parties also agreed. As the order hela je आपण जो रेंटेड भड़ा घरटी नहीं प्रफुल्ल कुमार साउंकर मासकु 2000 टंका से घरे आपणकर स्त्री राजी हेले जाइकिन आपणक सहित जीवन बीतवा पाई एवं आपण आज कोर्टू नहीं जीवे सहित भल सेठी रहिबे जहाँ सुविधा असुविधा हैला इमिडिएटली खबर देले आईएसी से कथा बुझीबे हैला ता छड़ा 15 दिन पर जने लेडी ऑफिसर को से पठेबे आपण माने केमती सेठी रहउछन्ती देखिबा पई आउ आपणकर पिला को आपण आनिकिनी तारो ता संगरे पिला सहित रहिबे हैला तो ए केस आसीबो जनवरी मासरे द्वितीय सप्ताह रे एवं आ भितरे केमती आपण माने चढुछन्ती कोन होउची से विषय हम नेक्स्ट डेट रे आपण माने पचारि किनी बुझियो आपण बुझिले तो जा हैला तो आपण फ्री कपाई in the custody of CWC. CWC is given the custody. All right. Acha. Since the child is now staying in the custody in the grandparents, as for the direction of the CWC shall bring the child and hand over to the petitioner and the opposite party number 1. Okay. So, हालात आउ किसी
सर मोर आपत्ति अभियोग अछि आपन ଆପତ୍ତି ବୋଲି ମୋର ଏଇଆ ଯେ ମୁଁ ଘରେ ଏନି ଟାଇମ୍ ରହିପାରିବିନି, କାହିଁକି ନା ମୁଁ ବାହାରକୁ ବେପାର କରି ଯିବି କିମ୍ବା ନଚେତ ଯୁଆଡୁ ଲେବର କାମ କରୁଛି ମାନେ ଲେବର କାମ ଉପରକୁ ମୁଁ ଚାଲି ଯାଉଛି। ଘରେ ମୁଁ ଏନି ଟାଇମ୍ ରହୁନି, ସପ୍ତାହଟେ କିମ୍ବା 10 ଦିନ 15 ଦିନ ମୁଁ ବାହାରେ ବୁଲି ଛାଉଛି କାମ ପାଇଁ ଆଜ୍ଞା। ସେଇ ଭିତରେ ସେ ଏକୁଟିଆ ରହିବା ପାଇଁ ଆଜ୍ଞା ପରମିଶନ ଚାହୁଁଛି।
ସେ ତ ରହିବ ଘରେ।
ପ୍ରତ୍ୟେକ ଘରେ ସେମିତି ହୁଏ।
କଣ
ତମେ
ସ୍ୱାମୀ
ଯିବା
ସବୁବେଳେ
ଗଲ ତମେ ଯେତେବେଳେ ଯିବ
ଆଜ୍ଞା
ସେତେବେଳେ ତାର ବ୍ୟବସ୍ଥା କରିଦେଇକି ଯିବ, ରାସନ ଥୋଇକି ଯିବ। ମଝିରେ ମଝିରେ ତାଙ୍କ କଥା ବୁଝୁଥିବ ଦୂରରେ ଥିଲେ ବି,
ଆଜ୍ଞା
ତେବେ ସେ ଜାଣିବେ ତମେ 10 ଦିନ ବାହାରେ ରହିଲେ ବି କିଛି ଅସୁବିଧା ନୁହେଁ।
ଓକେ
ଆଉ ତମେ କହିବ ମୁଁ ଯାଉଛି କାମରେ, ଆଉ ଫୋନଟେ ବି ନାହିଁ, ତାଙ୍କୁ ଯୋଗାଯୋଗ ବି ନାହିଁ, ରାସନ ବି ନାହିଁ, ସେ ଚଳିବ କେମିତି?
ରାସନ କାଟି ଦେଇଛନ୍ତି ଆଜ୍ଞା, ରାସନ କରାହେଇଥିଲା କାଟି ଦେଇଛନ୍ତି।
ସବୁ ଜିନିଷ ଏବେ ବୁଝିକିନି
ଏମିତି
ଯିବ।
ହୁଏ ନାହିଁ।
ଆଜ୍ଞା ସାର୍ ଆଜ୍ଞା ଆଜ୍ଞା
ମନରେ ରଖ ଯେ ମତେ ଚଳେଇବାର ଅଛି, ଆଉ
ଆଜ୍ଞା
ବାକି କଥା କଣ କେମିତି ଯିବ କଣ ଯିବ ସେ ବ୍ୟବସ୍ଥା କଲେ ତମେ ବୁଝେଇ ପାରିବନି ତମ ଘର କାମରେ ବି ତମେ ଚଳେଇକି ଯିବ।
ଏଟା ତମ ସଂସାର ତମେ ଚଳେଇବ। ହଁ
ଏଇଠି କହିବେ ଯେ ଆମେ ଯିବୁ ଆଜ୍ଞା ବଜାର, ସେ ଚଳିବ ଏକା, ସେଇଟା ଦରକାର ନାହିଁ ଏଠି। ପୋଲିସ ବ୍ୟବସ୍ଥା ଯାହା କରାହଉଛି, ଯାହା ତଦାରଖ କରିବା କଥା କୁହାହଉଛି, ସେଟା ଗୋଟେ ଆମେ ପ୍ରିକସନ ନଉଛୁ, କିନ୍ତୁ
ଆଜ୍ଞା
ଚଳେଇବ ତ ତମେ,
ଆଜ୍ଞା।
ହେଲା।
ନେକ୍ସଟ
Obligation. Item number 7.
So, Mr. Tripathi, this matter was listed last time on 30/10/2023. So, more than a month has passed. Any development made? Finally, 310. There is the outage.
I pray tomorrow can be.
Shall it activate? Activate. 6.
Item number 8.
The petitioner's minor daughter has been kidnapped.
Yes, what is the development?
Development question on development question.
So attempts have been taken in the meantime, but your client has not got any
No,
information.
no.
So you are too
My client apprehends that she might have been killed by the present accused persons.
No. କେତେ ବର୍ଷ ହେଲାଣି ତ?
Since the month of March,
କେତେ ବର୍ଷ ହେଲାଣି ଝିଅକୁ?
15, 16 years.
So there must be. All right, you wait. They are taking all sincere steps as it appears from the status report submitted. You are Mr. C. Mahanti.
Yes, sir.
What is your full name?
Chinmay Mahanti.
Chinmay.
Mr. Chinmay Mahanti, ASI of Police, Rajkanika Police Station, is present as per the order dated 7/11/2023. And he has produced the status report in connection with Rajkanika PS case number 170 dated 3/3/2023, in which various steps taken by him for rescue of the victim girl has been enumerated in detail. Copy of the status report has been furnished to the Learned Counsel for the petition. The IO submitted Mr. Mahanti's submitted that all sincere steps have been taken towards the detection of the case and face CDR in respect of the relatives and suspect person of the accused have been collected. CDR analysis, source of technology analysis, suspects persons are under surveillance, and during course of investigation, new spies were engaged to work out the clue. And he expects the victim minor girl would be rescued soon. Since further time has been sought for, release this matter in the second week of January 2024. You are the investigating officer?
Yes.
The investigating officer shall remain present on the next date and apprise this court about the development made in the meantime. Pre-copy of the order be handed over to the Learned Counsel for the state. So second week of January ରହିଲା କଣ development କରିଛନ୍ତି ଆମକୁ ଅଛି କହିଲେ?
Yes.
Item 9.
Item 9 by order dated 6/11/2023, the last order.
In this case, my lord, the IO has gone to Hyderabad. They have gone. Report has come.
Hyderabad in connection with this particular case.
On 9/10/2023, the order was passed to form a team.
Yes, sir. Might have taken some efforts and gone.
Yes.
So when he is expecting to return?
And that is stationary. Yes. On 3/11, they had gone to Hyderabad. Last line, lordship. Last.
In the meantime, on 29/11/2023, SI Bon Bihari Satpathy Aksha had gone to look at them. No, ତା ଉପରେ ଯୋଉଟା ଲେଖିଛନ୍ତି, information was given that his daughter so-and-so has married to the accused, Ashish Sethi, after their elopement, and they were staying at Hyderabad. In the meantime, they have returned from Hyderabad but unable to say the so and so. One of the friends, acha. So let him return with like we are posting this case. Whether we will keep it in the month of January. Let him. The Learning Council for the state has produced the status report of the case which was instituted in connection with the kidnapping of the minor daughter of the petitioner. And the report has been submitted by the IIC Sadar Police Station, Balesur, dated 4/12/2020, in which it is mentioned that on 29/11/2023, SI Banabihari Satpathy IO had gone to Hyderabad with the staff to locate and rescue the victim girl, and he has not yet returned. Land Council for the state seeks some further time for the return of the SI to apprise this court about the development. In view of such submission, a copy of the report has been furnished to the Land Council for the given matter petitioner. Put up this matter in the second week of January 2024.
At note 10,
Last one 6/11/2023. There was direction. ଗୋଟେ ଗୋଟେ
ନା କୁହନ୍ତୁ କଣ କଲେ ଆ ଭିତରେ ଆପଣ ମାସେ ତ ହେଇଗଲା
सर लॉ एंड ऑर्डर ड्यूटी रे 14-15 दिन रहीगली सर तापर से बैंक को तार ट्रांजैक्शन मागी तार सीडीआर भी मागी सर किछि तार घर भी जाई चेक करिछु तार माउसी घर के भी जाइथिली किछि सर तार मिलुनी सर
ସେ ପିଲାର ଯୋଉ ଜଗନ ସେଠି is the accused
ଆଜ୍ଞା
ତାର ଫ୍ୟାମିଲି ମେମ୍ବର୍ସ
ହଁ सर तार काका तार बड़ापा तार घर ता बड़ापा ता काका रोजन कलकत्ता तांको घरे तांकर
ଯାଇଥିଲେ ନା ରହୁଛନ୍ତି
ହଁ सर ଯାଇ सर
ତାର ଫଟୋ ଅଛି ଆପଣଙ୍କର ଭିକ୍ଟିମ ର ଆଉ ଏଇ ଯୋଉ ଆକ୍ୟୁଜ୍ଡ ର ଫଟୋ ଆପଣଙ୍କ ପାଖରେ ଅଛି ତ
सर
ଆପଣ ତାଙ୍କ ରିଲେଟିଭ୍ସ ଙ୍କ ଘରକୁ ଗଲେ ତ ସେ ମନା କରିଦେବେ ନା ଏଠିକି ଆସି ନଥିଲେ
ନା सर घर सर्च करछि सब
हो ସେ କଣ ସେଠି ଆଉ ଆପଣ ଯାଆନ୍ତେ ସିଏ ଥାନ୍ତେ ନା କଣ ସେ ଲୋକାଲିଟି କୁ ସେମାନେ ଆସିକିନି ରହିଥିଲେ କି ନ ରହିଥିଲେ ଏ ବିଷୟରେ ଏଇ ଯୋଉ ସାଇ ପଡିଶାରୁ ସେଠି ବୁଝିଥିଲେ
ବୁଝିଛି ସର
କଣ ହେଲା
ବୁଝିଛି ତାଙ୍କର ସରପଞ୍ଚ ଦିଟା ସରପଞ୍ଚ ବୁଝି ତାଙ୍କ ସହିତ ବି ଯୋଗାଯୋଗ ରଖିଛୁ କିଛି ଯୋଗାଯୋଗ ରହୁନି ତାଙ୍କ ସାଥିରେ
ଏ ପିଲା କଣ କରେ
ସେ ସର ବାହାରେ ଗୁଜୁରାଟରେ ରହୁଥିଲା
ଆରେ କଣ କରେ ମ ତାଙ୍କ ଘର ଲୋକ ତୁ ଜାଣିନାହାନ୍ତି
କମ୍ପାନୀ ଏବେ କିଛି ସାର୍ ଏଠୁ ଯିବା ଠାରୁ ତାର ସହିତ ଆଉ କିଛି ଯୋଗାଯୋଗ ରହୁନି ତାଙ୍କର
ତା ପୂର୍ବରୁ କଣ କରୁଥିଲା
ସେ କମ୍ପାନୀରେ କାମ କରୁଥିଲା
କମ୍ପାନୀ କୋଉଠିଆ କମ୍ପାନୀ
ଗୁଜୁରାଟରେ ସାର୍
ଆଉ ଝିଅ କଣ କରେ
ଝିଅ ସାର୍ ପଢୁଥିଲା ନବମ ଶ୍ରେଣୀରେ
ନବମ ଶ୍ରେଣୀରେ
ତାର ମାମୁଁ ଘରେ ରହି ପଢୁଥିଲା ସାର୍।
କେତେ ବର୍ଷ ତା ଡେଟ୍ ଅଫ ବାର୍ଥ କେତେ?
ସାର୍ 16 ବର୍ଷ।
28 to 2007.
You have got no information about. बैंक ट्रांजैक्शन किसी नहीं पिलार अकाउंट अछि
चेक कर वेरीफाई करछि सर
किसी नहीं
दुटा ना सर। ଆଉ କିଛି ଦିନ ସମୟ ଦିଅନ୍ତୁ ସାର୍ ଦେଖି।
Mr. Kailash Chandra Mahalik, SI of Police, Singla Police Station, Baleswar, is present as per the order dated 6/11/2023 and submitted the status report wherein various steps taken for the rescue of the victim girl has been mentioned. Copy of the status report has been supplied to the Land Council for the petitioner and the same is also taken on record. You are the investigating officer.
Sir.
The investigating officer seeks some further time for rescue of the victim girl as well as to apprehend the accused. Put up this matter in the second week of January 2024. He shall remain present on the next date and apprise this court about the development, if any, made in the meantime. Free copy of the order be handed over to the Land Council for the state. Second week. On development ala jane be asini sir. Yeah.
Item 11.
As per the direction, my lord, I have appeared before the PS, my lord, and given photograph.
Wait. Copy the list. मैडम कहतु कौन डेवलपमेंट हला कहतु आ भितरे 30/10 रे आस्तिला केस लास्ट टाइम मासे हिराणी कौन डेवलपमेंट हला कौन करले
सर सीडीआर एनालिसिस करथिलु सर किछि क्लू मिललानी तार अलेज्ड पर्सन रो ता मामू रो माउसी रो रेड करथिलु
कोठी करना घर कोठी
मामू रो सर हमरो बाघमारी खोर्धा जिल्लार बाघमारी पोड़पोड़ा गाँ रे सेठी करथिलु आ बांकी रे ता माउसी रो रहउछन सेठी किछि से माने जान नाहंती कहले सर
फोटो कलेक्शन करथिले
सर पिटिशनर को कंप्लेनेंट को पचारथिले सर से मना कले
कोनटा मना कले
फोटो
पब्लिकेशन छाडंतु माने फोटोटा आपण पर रहिला ना नै पुन अछि ना नै विक्टिम रो अक्यूज रो फोटो कारण आपण जो लोकालिटी को जाउचंती से जो तांकर रिलेशन मना कर देथिले भी आपण लोकालिटी रे पचार देई परिबे साइड घरे एमतिया पिला के आस्थिले की कोन तो सेतै दरकार फोटो तो फोटो जार अवेलेबल हुई थी के आपण क्लाइंट पर किसी इंस्ट्रक्शन नहीं हो
So what is your next plan? What is the next plan you have with this supervising authority?
आपण जो जहा पचरा जाउची जो पुअर हो झियो घर तो जीवार नहीं पुअर जो रिलेटिव्स माने जोड़ जोड़ सब बाहर रहउछंती सेठिकी सब गुड़ाक कलेक्ट करिकिन जाइकिनी बुझिकिन आसिलेनी
ସାର୍
ना खाली दीटा जगह को जाइछन जो दीटा कहउछन
ସାର୍ ଏଇ ଦିଟା ଜାଗା ହିଁ ତା ମାମୁଁ ଘର ମାଉସୀ ଘର ଆଉ
आउ तार के नांती
ଅଛନ୍ତି ସାର୍ ସେମାନଙ୍କ ସହିତ ତାଙ୍କର ସେତେ ଇଏ ନାହିଁ ଆଉ ସେଇ ପାଖରେ ହିଁ ଗୋଟେ ବସ୍ତିରେ ହିଁ ତା ଖୁଡି ଦାଦା ଘର ସମସ୍ତେ ରହୁଛନ୍ତି ସାଇଡ୍
आउ सांग एमनक पाखु किछि कांटेक्ट जोगाजोग नाही
ସାର୍ ନା ସେ ପୁଅ ଆକ୍ଚୁଆଲି ସାର୍ କାହା ସହିତ ବେଶୀ ମିଶେନି ସେ ବସ୍ତିରେ ତ ତାର
नहीं घर लोकଙ୍କୁ नंबर कोनोसी से नंबर तो बंद ही जाइछि अन्य नंबर किछि आसुनी किछि
ସାର୍ ତାଙ୍କ ଘରେ ତା ମା ହିଁ ଯାହା ଅଛନ୍ତି ସିଏ ଟୋଟାଲି ଫୋନ ୟୁଜ ହିଁ କରୁନାହାନ୍ତି ଆଉ ତାଙ୍କ ଆକ୍ୟୁଜ ର ବାପା ଯିଏ ସେ ପାରାଲିସିସ୍ ପେସେଣ୍ଟ
अच्छा
ତ ସେ ତାଙ୍କ ମା ହିଁ ଗଲେ ମାଙ୍କ ସହିତ ହିଁ ଯାହା କଣ୍ଟାକ୍ଟ ହେଇପାରୁଛି ସିଏ ଟୋଟାଲି ଫୋନ ୟୁଜ ହିଁ କରୁନାହାନ୍ତି
वर्तमान झीर बयस केते हला
ସାର୍ 17 ବର୍ଷ 2 ମାସ
अच्छा
ସାର୍ ଟିକେ ଟାଇମ ଦେଲେ କରିଦେବୁ ସାର୍
अकाउंट किछि थिला पिलार
ନା ସାର୍
कोन से करे
କିଛି
करूथिला
कर
वो किछि करेनी से एका गां पिला
ସାର୍ ହଁ ସେଇ ଗୋଟେ ବସ୍ତିର
अच्छा Yes, the question which has been put to you, आपण जो प्रश्न पचारला आपण how you are planning to trace out the victim, what is your next course of action?
Because with this, otherwise you have nothing. So how will proceed next? What is your next plan?
ସାର୍ ପୁଅର ଯୋଉ ଭାଇ ଅଛି ସାନ ଭାଇ ତା ନମ୍ବରରୁ ଦିଟା ଆମେ ପାଇଛୁ ନମ୍ବର ଯୋଉଟା କି କୋଲକାତା ବେସ୍ ରହୁଛି ତା ସହିତ ସେ ବହୁତ ଟାଇମ କଥା ହଉଛି ତ ସେଇ ନମ୍ବର ଦିଟା ଆମେ ଏଲଆଇ ରେ ପକେଇଛୁ ସାର୍ ଆଉ ସେଇଥିରୁ କିଛି କ୍ଲୁ ମିଳିଛି
ତା ସାନ ଭାଇ ଏଠି ଗାଁରେ ରୁହେ
ନାଇଁ ସାର୍ ସିଏ ପଟିଆରେ ଗୋଟେ ହୋଟେଲରେ କାମ କରୁଛି ବର୍ତ୍ତମାନ
अच्छा सुचिस्मिता खंडे SI of police IUCAW Bhubaneswar UPD is present as per the order dated 30/10/2023 and she has also produced the up-to-date status report wherein it is indicated about the various steps taken by her for rescue of the victim girl and also to arrest the accused Chandan Nayak. She seeks some further time. In that respect, the status report is taken on record. Copy of the status report has been furnished to the Land and Council for the petitioner. List this matter in the second week of January 2023. The investigating officer shall remain present on the next date with the up-to-date instruction. Second week of January.
Obliged.
Item 12.
My lord. Order dated 6.
Wait. कैसे को फेल से नजदीक है जो गत थर जो आसथिले
सर
ସେ କହିଥିଲା ଯେ ମାନେ ମୁଦାଲାର ଯିଏ ବାପା ସିଏ କହିଲେ ଯେ କେସ୍ ଟା ଯଦି ହାଇକୋର୍ଟରୁ ଉଠେଇ ନବ ତାହେଲେ ଆମେ ଭିକ୍ଟିମ୍ ଗାର୍ଲ ବିଷୟରେ ଆପଣଙ୍କୁ ଜଣେଇବୁ ଏ ବିଷୟରେ ସେଇଥିପାଇଁ ଆପଣଙ୍କୁ କୁହାଯାଇଥିଲା ଯେ ଯାଇ ପଚରା ପଚରି କରିବେ
सर
ତ କଣ ହେଲା
सर ता बापा माँ टोटाल फैमिली सारे घरे लॉक थिला एचरे 9 तारिख रे जाइक ता घर हाउस सर्च करिकी विटनेस मानकर 161 भी कर सर आ से घरे नथिले सर लास्ट मु आस्तिली सर सर डाकिथिले ए जोठिया 23/11 रे से गोटे एबीएलपीएल अप्लाई करथिले ता देर सर से कन्सिडर पाइचंती एबे से मु काली खबर पाइ सर से घर को जाइचंती ता बापा माँ ता भाई
एंटिसिपेटरी बेल कोन अलाउ ही जाई ना कोन
सर नाइ सर आलो ही नहीं
प्रोटेक्शन
सर
तो प्रोटेक्शन दिले माने वर्तमान से माने अवेलेबल ही परिबे ना
हाँ
किछ
सर सर
असुविधा नै
सर मु तो काली पळे आसिली से आसी घरे पहुंचंती बोली सर मु खबर पाइछि नेक्स्ट जाइक सर तांकठो
कारण
खबर
ए टाइप रो स्टेटमेंट जदी अक्यूज्ड रो बापा दउची जे आकु कहूची माने पिटिशन रु तमे केस उठी आनो मु झियो कोठी अछि तमु जणै ता माने से आइदर मिछ कथा हेतिबो नचे जानिथिबो किछि सेत पई कहूथिबो तो कोन प्रकृत कोन जिंसटा आपन कुहाइतला visit करकिनी आपण तांग हाउस को बट they were absconding now they have got the interim protection order so now we can make a necessary inquiry from them what is the correct state of affairs whether they have stated so to the father the petitioner or not एमती किछि कहिथिले कि नाही
सर सर
तनु तांकर by the way what is the date of birth मर्तन केते हलानी जियो को
16 my lord
तो होलो
16
पिला कोठी गार से गार
same village
कोन करे पिला कोन करे पुओ
लेबर काम सर
लेबर
कंपनी
जियो पढुथिला ना पाठ छाड़ देइतला
से continuing her study
अच्छा आपण रिलेटिव्स हाउस किसी
सर सर
करचंती
प्रीवियसली करथिली सर नेक्स्ट 19/11 भी करछि सर
अच्छा आपण लेक्चर जो वेस्ट बेंगल बॉर्डर एरिया आपण सेठी ये करथिले
सर सर जो फांडी रे अछि सर 4 to 5 किलोमीटर बेंगल बॉर्डर सर
बॉर्डर आरंभ
सर सर
अच्छा झियो रो बापा मा कोन करंती बापा कोन करे
बापा
माने पिटिशनर
हां पिटिशन
घरु गलाउ किछि टंका पैसा सुना ए सब नै कि जाईची
सेमती किछि हमहु कहिनाती जे
तार किछि अकाउंट अछि माने केते दिन धरि से माने मैनेज करि परिबे घटना तो हेलानी एफआईआर
सर 7 मास सर
7 मास
सर सर से लेबर काम करे प्रीवियसली से जो हमर सर विक्टिम रो ब्रदर इन लॉ सहित से एकाठी सर रहउतले पुणे रे गोटे कंपनी रे काम करतले आफ्टर ऑकरेंस से पिला तार जो ब्रदर इन लॉ पाकू छाड़ी चल जाईची
अच्छा
चली गला परे सर तारा व्हेयर अबाउट किछ खबर
ब्रदर इन लॉ से किछ जोगाजोग
ना सर मु ब्रदर इन लॉ आ तार जो सिस्टर जे सहित सर बहुत थर जोगाजोग करी सर ता पाखरे कोनोसी फोन नाही तेणु से जोगाजोग सेठार भी सर रहुनी से आउ हम टीम सर जाइतला प्रीवियसली
को जगह रे से
सर पुणे सर
Alright, you carry forward out लेखन the नाय लगी Mr. Fakir Charan Pradhan SI of Police Nemal
नामपो सर
Nampu Jaleshwar Baleshwar is present and he has submitted the status report dated 3/12/2023 indicating the steps taken by him for rescue of the victim girl and also to arrest the accused. The status report copy has been upon the copy. Status the status report copy. Let it this copy of the status report be furnished to the land council for this petitioner. The IO prays for some more time to carry forward his investigation and take necessary steps for rescue of the victim girl and to arrest the accused. Place this matter in the second week of January 2024. The IO shall appear before this court on that day, next date, and apprise this court about the development if many made need time. So second week रे रहला अपन आसी development जाला.
Obliged mail.
Item 13.
ଷୋହଳ ପୁରୀ ଗଲାଣି 17 ଚାଲିଛି ତାମାନେ କୋଉଠି କୋଉଠି ଗଲେଣି ଆପଣ
ସାର୍ ତାଙ୍କର ସାର୍ ଯୋଉ ଆଲିଜା ଆକ୍ୟୁଜ ତାଙ୍କର ମାମୁଁ ଘରକୁ ବି ସାର୍ ଯାଇଥିଲେ ରେଡ୍ କରିବା ପାଇଁ
କାହା ମାମୁଁ ଘର
ସାର୍
ଆକ୍ୟୁଜ ର
accused ର।
ହଁ
ଆଉ ସାର୍ ତାର ଯୋଉ ଅପା ଯିଏ
ହଁ
ଅପାଙ୍କ ଘରକୁ ବି
କୋଉ ଏରିଆରେ ସେମାନେ ରହୁଛନ୍ତି
ସାର୍ ସେଇଟା ସାର୍ ଖଣ୍ଡପଡା
ଆଚ୍ଛା
ଅପା
ହଁ
ଘର ସାର୍ ଦିଟା ଅପା ଘର ସାର୍ ଆଉ ତା ମାମୁଁ ଘର ସାର୍ ଟିକେ ଗାଁଠୁ ଟିକେ ଡିଷ୍ଟାନ୍ସ ରେ ଅଛି ଟିକେ ସୁନସାନିଆ ଜାଗା
କାହାର ଡିଷ୍ଟାନ୍ସ ଅଛି
କମ୍ପ୍ଲେନାଣ୍ଟ ଆକ୍ୟୁଜ ର ତାଙ୍କ ଗାଁ ସେମ୍ ଗାଁ ତାଙ୍କ ଗାଁରୁ ଟିକେ ଡିଷ୍ଟାନ୍ସ ଅଛି ସେଇଟା ଯୋଉଟା ତା ମାମୁଁ ଘର ଯୋଉଟା ଜଙ୍ଗଲ ଭିତରେ ଅଛି ପ୍ରାୟ ସେଇଠି ଆଲିଜ କରୁଛନ୍ତି ସେଇଠି ରହୁଛନ୍ତି ବୋଲି ପ୍ରାୟ କହୁଛନ୍ତି ତ ସାର୍ ସେଇଟାକୁ ରେଡ୍ କରୁଛୁ ସାର୍
ଆଉ ଯେ ଗଲେନି
ହଁ ସାର୍
କି ଆପଣ ପାଖରେ ଖବର ଆସିଲା ଯେ ଏଇ
ନାଇଁ ସାର୍ ମାନେ ଆମ କମ୍ପ୍ଲେନାଣ୍ଟ କହୁଛନ୍ତି ଯେ ସେ ସେଇ ଜାଗାରେ ରହୁଛନ୍ତି ବୋଲି ତ ଆମେ ସେଇଟା
ଯଦି କୌଣସି ଖବର ମିଳିଲା ତାକୁ ଯିଏ ଏତଲାକାରୀ ବା ପିଟିସନର ସେ ଯିଏ ଏଇ ଜାଗାରେ ରହୁଛନ୍ତି ବୋଲି ସିଏ ଆପଣଙ୍କୁ ଜଣେଇଲା ତାର ଆପଣ ତଦନ୍ତ କରିବେନି ଭେରିଫାଏ କରିବେନି
ସାର୍ ଆଉ ରେଡ୍ ବି କରିଛୁ ସାର୍ ସେଇଟା ସେ ରହୁନାହାନ୍ତି ନାଇଁ ସାର୍ ଆଉ ସାର୍ ତାର ସାର୍ ଯୋଉ ଆକାଉଣ୍ଟ ବି ସାର୍ ଆମେ ଭେରିଫାଏ କରିଥିଲୁ ସାର୍ ସେ ଯୋଉ ଆଲିଜା ଆକ୍ୟୁଜ ର ତ ସେ ବ୍ୟାଙ୍କରେ ସାର୍ ତାର ଓପନ ହେଇଛି କି ନାଇଁ ବୋଲି ସାର୍ ସେଇଟା ବି ନଥିଲା ସାର୍
ଇଏ କଣ କାମ କରେ ପିଲା
ସେ ଲେବର କାମ କରନ୍ତି ସାର୍
ଝିଅ ପଢାପଢି କରୁଥିଲା
ଆଜ୍ଞା sir.
9th class.
I think
9th
9th
ରେ?
or 10th.
15 years something, madam.
No, now she has
No, sir.
date
May I
of
submit,
birth
madam?
is
If your lordship can have glance to the order dated 25/9/2023. How they are filing affidavit and instruction, madam. Your lordship, order number 4. Lord Counsel for the state has received the written instruction from the inspector in charge of Sadar Police Station dated 23/9/2023, wherein it is stated that sincere steps were taken to trace out the minor daughter of the petitioner as well as the apprehension of the accused, and there has been a discussion with the father of the victim and the father of the accused in presence of law and order. Your lordship, today the instruction paragraph 9, madam, and everything. Soon after the registration of the case, Rankanithi Pradhan, father of the alleged accused Battu alias Uddha Pradhan, left his house to Kerala for work. Till date, he has not returned to his village and correct address of Kerala where Rankanithi was working. And mother of the accused has frequently remained absent near the village, and so he could not interrogate to find out clue where about his son Battu Pradhan.
To that respect, my lord, I have inquired with the ISC once. He talked in telephone with the accused father, my lord. Though he's staying outside, he has talked with that accused father, my lord.
ଆପଣ ସେଦିନ କହିଲେ
ଆଜ୍ଞା
ଯୋଉ
that thing
ରିଟିନ
was
ଇନଷ୍ଟ୍ରକ୍ସନ ଟା ପ୍ରଡ୍ୟୁସ କଲେ ସେଠୁ
ଆଜ୍ଞା।
ଜଣା ପଡୁଛି ଲୋକାଲ ସରପଞ୍ଚ ର ପ୍ରେଜେନ୍ସ ରେ
ସେ
ଉଭୟ
କଥା
ପକ୍ଷଙ୍କ
ହେଇଛନ୍ତି
ଭିତରେ ଡିସ୍କସନ ହେଲା ସେଇ କଥାଟା ଓଭର ଫୋନ ହେଇଥିଲା
Yes, your lordship. That I ascertained from it.
not the physical presence.
No.
My lord, as for my instruction, my lord, father of the accused is my lord in the village. Father of the accused.
ଆମର ଫାଦର ଅଫ ଦି ଆକ୍ୟୁଜ ସାଙ୍ଗରେ କିଛି କାମ ନାହିଁ
ସେ ଡିସ୍କସନ ହେଇଥିଲା ଯେ 7 days ଭିତରେ ତା ପୁଅକୁ ସେ ଆଣିବ କେରଳରୁ ତା ବାପା ତେଣୁ he has the knowledge of about the address of the accused man. My humble servant.
yes what is madam କଣ କହୁଛନ୍ତି ସେ ବାପା କଣ କୁଆଡେ ତାର ସେଇଠି ରହୁଛି ଆସି ଗାଁରେ
ନାଇଁ sir, ଗାଁରେ ନାଇଁ sir.
କେବେ ଲାଷ୍ଟ ଟାଇମ ଯାଇଥିଲେ
ଲାଷ୍ଟ ମତେ ଏଇ ଯୋଉ 2 ଦିନ ତଳେ ବି ଯାଇଥିଲି sir. କାଲି ବି ଯାଇଥିଲି sir.
ତାଙ୍କର ଇଏଟା ହଉଛି ଆପ୍ରିହେନ୍ସନ ହଉଛି
ସେମ ଗାଁ ତ sir, ସେ ଗାଁରେ ରହୁଛି.
ଆପଣ ଲୋକାଲିଟିରେ ଏମିତି ରଖନ୍ତୁ ଯିଏ କି ଆପଣଙ୍କୁ ଇମିଡିଏଟଲି ଖବର ଦବ ଯୋଉ ମୁହୂର୍ତ୍ତରେ ଧର ଆସିବ ସେ ଇଏ ତାର ଆକ୍ୟୁଜ ର ବାପା ତାକୁ ଏପର୍ଯ୍ୟନ୍ତ କିଛି ପଚରା ପଚରି କରୁନାହାନ୍ତି ଯାହା
sir, ସେ ତ ନାହାନ୍ତି sir, ଘର ବି ତାଲା ମାରିଛି, ସେ କଣ କି ଖାଇଗଲାଣି sir, ଘରକୁ ଟୋଟାଲି ଆସୁନାହାନ୍ତି. ଯଦି ଘରକୁ ଆସିଥିଲେ sir ଏମିତି ମୁଁ ତ
କିଏ ଆପଣଙ୍କୁ ଖବର ଦଉଛି କାଲି ପରଦିନ ଯାଇଥିଲେ
ପରଦିନ ଯାଇଥିଲେ ସେଟା ମୁଁ I am not disputing matter, but he is residing in the locality and also available in the village, and this is the statement matter.
That is there, but the IAC is saying that
their written instruction contradicted to each other.
It's all right that but when we are asking you in your presence
my instruction his
and
father
the lock has already got rusted. How could it be? If there is a use of the lock, how can it get rusted? Now it
the
is
other person must have ସେ ନିଶ୍ଚୟ କହିଥିବେ ପଡିଶାରେ ମଧ୍ୟ ଖବର ଦେଇଥିବେ ଆଇଲେ ଖବର ଦବାକୁ ଏମିତି ଜଣେଇଛ ନା ନାହିଁ
sir.
Okay, we are granting for the time you carry forward your investigation and apprise
may I pray, you directed the SP to only supervise the matter.
That was given earlier.
That was earlier given.
So you have a doubt in the manner of investigation conducted by the IO?
Yes, ma'am.
And is she
not
helping?
Yes.
She is helping?
Yes, my lord. My lord.
Where from we say this?
My lord, your lordship, 13/10/2023.
Clearly order achi superintendent of police Nayagarh shall supervise the investigation of the case.
My lord.
We'll seek a report from the SP. All right.
Yes, my lord. Your lordship, call for a report from the SP.
Raivari Tiria, SI of Sadar Police Station, Nayagarh. is present and she has produced the status report dated 4/12/2023, which is taken on record. Various steps taken by her for the rescue of the minor girl and also to arrest the accused are enumerated in the said report. The report is taken on record. Copy of the report has been furnished. Furnished to the Law and Counsel for the petitioner, who submitted that even though this court directed as per order dated 30/10/2023 to the Superintendent of Police Nayagarh to supervise the investigation of this case, but the same is not being done. Court of this matter in the second week of January 2024, the investigating officers shall remain present on the next date with instruction about the development, if many, made in the meantime. The Superintendent of Police Nayagarh shall submit a report to this court through the London State Council regarding his part of supervision of the investigation of the case. Free copy of the order be handed over to the London Council for the state. So second week रे रहिला आपण डेवलपमेंट कौन हला सी जणेबे से मधे एसपी गोटे रिपोर्ट देबे आपण कोन से आपण को सुपरवाइज करूछन जे आपण इन्वेस्टिगेशन विषय से विषय मधे रिपोर्ट देबे. यस.
Item 14.
Item 14 page of Golgar. Good and last occasion lordship directed to file affidavit regarding the cases filed by the petitioner and the wait. ଆପଣ ସେଦିନ ପିଲାମାନଙ୍କ ସହିତ ସମୟ କଟେଇଲେ? ଆଗକୁ ଆସନ୍ତୁ।
ସାର୍ ବେଶୀ ସମୟ ରହିନି ପିଲାଙ୍କ ପାଖରେ।
ଆଚ୍ଛା, ତାପରେ ଆଉ ଖବର ଦେଇଥିଲେ କି? ଆପଣଙ୍କୁ ତ ଦିଆ ହେଇଥିଲା ଯେ ଆପଣ ଯେତେବେଳେ ଚାହିଁବେ ଆପଣ ପିଲାମାନଙ୍କୁ ଦେଖା କରିବା ପାଇଁ ଆପଣ IIC ବୋଲଗଡ଼ ଥାନାକୁ ଜଣେଇଲେ ସେ ଆରେଞ୍ଜମେଣ୍ଟ କରିବେ ବୋଲି। ଆଉ ଜଣେଇଥିଲେ?
ହଁ ସାର୍ ଯାଇଥିଲି, 2 ଥର ଯାଇଥିଲି, କିନ୍ତୁ ପିଲାକୁ ପାଖକୁ ଆଣିଲା ବେଳକୁ ମୋ ଶାଶୁ କୋଉଠି ଥାଆନ୍ତି, ସେ ପାଖାପାଖି ରୁହନ୍ତି, ଯୋଉଥିପାଇଁ ମୁଁ ପିଲାଙ୍କ ସାଙ୍ଗରେ ବି ରହିପାରେନି ବେଶୀ ସମୟ। ବାସ୍ ପିଲାଙ୍କୁ ଆଣିବାକୁ ଗଲା ମାନେ ତା ବାବା କହିବେ ତୁ ପିଲାକୁ ନବାକୁ କିଏ ସେ?
ନାଇଁ ଆପଣ
ମୋ ପିଲା ସାଙ୍ଗରେ ତୁ ଲାଗେନା।
ଆପଣ ଯେତେବେଳେ ଡେଟ୍ ଇଏ ହେଲା ସେମାନେ କାହାକୁ ଦେଖିଥିଲେ? ସେ ଆପଣ ଖାଲି ଟାଇମ ଇଏ କଲେ କଣ ହବ? ସେ ମାକୁ ଯଦି ମା ପାଖକୁ ପିଲାଙ୍କୁ ନ ଛାଡିବେ ତାହେଲେ ପର୍ପସ ଟା କଣ ହେଲା?
ରଖି ସାର୍ ପିଲା ହିଁ ଇଣ୍ଟରେଷ୍ଟେଡ ନୁହନ୍ତି ସେଠିକି ଆସିବାକୁ। ଯେତେ ସମୟ ଦେଖା ହେଇଛି ଯେତେବେଳେ ଟାଣିକି ନଉଥିବେ ପିଲା ପୁରା ଛାଟି ପିଟି ହୁଅନ୍ତି ସାର୍। ସେଥିପାଇଁ ମାନେ ସାର୍ ଗୋଟେ ହ୍ୟୁମାନିଟି ଦୃଷ୍ଟିରୁ ମୁଁ ବି କୁହେ ସ୍ନେହରେ ନିଅ, ଆଉ ସେମିତି ଇଏ କରନି ବୋଲି ମୁଁ ବି କହିଛି ସାର୍। ତ ସେ ଭିଡିଓ ରଖି ସାର୍ 2 ଦିନର
ନାଇଁ ଠିକ ଅଛି। ସେ ପିଲାଙ୍କୁ କଣ ସେମାନେ ଶିଖେଇଥିବେ କଣ ହେଇଥିବେ। ମା ପାଖକୁ ପିଲାମାନେ ଆସୁନାହାନ୍ତି ମାନେ ତାଙ୍କ ମୁଣ୍ଡରେ କଣ କିଛି କଥା ଭର୍ତ୍ତି ହେଇଛି। ସେ ପିଲା ଗୁଡାକ ସେଦିନ ସେ ଆସିଥିଲେ, ତାଙ୍କ ପୁଅଟି ଆସିଥିଲା, ସେ ବି ସେଦିନ ପଚାରିଲା ବେଳକୁ କହିଲା ଯେ ବାପା ପାଖରେ ରହିବ ବୋଲି ସେ ଫୋନ କରୁଥିଲା। କେତେ ବର୍ଷ ହେଲାଣି ନିଜ ପିଲାଙ୍କଠୁ ଆପଣ ଅଲଗା ହେଇ ରହୁଛନ୍ତି?
2 ବର୍ଷ।
2 ବର୍ଷ ହେଲାଣି।
ସେ ଛୁଆ କ୍ଷୀର ଖାଉଥିଲା, ଜବରଦସ୍ତି ଛଡେଇକି ରଖିଛନ୍ତି ସେଇଦିନ। ତାପରେ ବି ଥାନା ଠିକି ଯାଉଛି ଦେଖିବା ପାଇଁ କି ମତେ କୁହାଯାଉଛି ନା କଣ ନା ତୁ ପା ପଳେଇଥିଲୁ, ତୁ ଏଠିକି କୁଆଡେ ଆସିଲୁ? ମୁଁ କହିଲି ଯଦି ମୁଁ ପଳେଇଥିଲି ତ ମୁଁ ତମ ବାପା ଘରେ ଥିଲି, ତାହେଲେ ତମେ କାହିଁ ବାହାରେ ଲୁଚିଥିଲ? ତ ମୋ ଶାଶୁ ହିଁ ମତେ ପିଲାକୁ ଦେଖିବାକୁ, ବଡ ପୁଅକୁ ବି ଧରିଥିଲି ମୋ କୋଳରେ, ଶାଶୁ ଆସିକି ଉଣ୍ଡି ଦେଇକି ଗଲେ, ମୋ ବଡ ପୁଅ ବି ମୋଠୁ ଛାଟି ପିଟି ହେଇକି ପଳେଇଛି। ମୁଁ ତାକୁ ଧରିକି ବସିଥିଲି ବି 10 ମିନିଟ୍ ନା 15 ମିନିଟ୍ ଖଣ୍ଡେ।
ଯେତିକ ବାଜ୍ୟ କଥା ସବୁ ପିଲାଙ୍କ ମୁଣ୍ଡରେ ପୁରେଇକିନି ଏସବୁ କାହିଁ ସେମିତି କରୁଛ?
ନାଇଁ ଆଜ୍ଞା,
ତାର ଅଧିକାର ନାହିଁ। ତମେ ଏସବୁ କଥା କଣ? ସିଏ ଦୁନିଆକୁ ଆଣିଛନ୍ତି। ତାକୁ ଏସବୁ କଥା ପିଲାମାନଙ୍କ ମୁଣ୍ଡରେ ପୁରେଇ ତାକୁ ସେମାନେ ଚାହୁଁନାହାନ୍ତି ମା ପାଖକୁ ଯିବା ପାଇଁ। ମା ଟା ଡାକୁଛି, ତାକୁ ଇଏ କରୁଛି। ସବୁ କଣ ଜିନିଷ ସବୁ? ତମ ମା ଏମିତି କଣ
My lord, on behalf of
Next week. Yeah, 1 week after. Yes.
my lord, on behalf of Mr. Lalitendra Mishra, due to the sad demise of his mother, I pray for an adjournment.
When you want this case?
My lord, I pray for an adjournment.
Quebec को रखियो अपन
2 weeks later.
Please. What is the last date? What has been done? Resolution. Oh, this is that matter. Okay. 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 Mention is made on behalf of Mr. Lalitendra Mishra that there is bereavement in the family. In the matter we adjourn for 2 weeks. Release this matter in the second week of January 2024.
My lord, item number 30 also. I pray for an adjournment.
30.
Item 30. 30.
Yes. All right. Same order for them. Item number 30.
Obligement.
Item 16.
In my lord, I pray for pass out.
Just.
Rescue protectant
केस नंबर उड़ा को लिखा है कि ठीक से कितने किसी नंबर हो गया yes
victim rescued in this
Sir, victim has been rescued and accused in custody.
Shrikant Kumar Pati, the officer in charge of Pirahat Police Station, Bhadrak, is present and he has produced the up-to-date status report of Pirahat PS case number 187 dated 8/11/2022, wherein it is mentioned that the victim girl has been rescued and the accused has been arrested and he is now in judicial custody. The status report is taken on record. In view of the status report furnished, no further order is required to be passed because the PCRL, which is accordingly disposed of. Yeah.
My appearance for the petitioner.
Land Council. You are for the petitioner, no?
Yes.
Mr. CHITTARANJAN Mahapatra, Land Council for the petitioner, is present. Yeah. Personal appearance of this.
Item 17.
Yes, Mr. Jali.
My lord, there was a direction to file counter.
What is the order? Last order is?
Last order.
We had to file a counter, my lord, in this case.
No, कौन है ये order पे?
Matter
Premature release.
6/11/23. Planning Council for the state pointed out from the pair that premature was rejected by the State Sentence Review Board on account of the adverse report of the district authority as has been highlighted in Annexure A. I will seek some time to produce the adverse report and also to file counter affidavit by the next day, giving copies of so on. So yes, sir, where is your counter affidavit?
Counter affidavit has gone for vetting, my lord. We pray some more.
कौन
Vetting पे जाइए.
अच्छा.
We pray some more. This is the instruction.
So tell us the whether it will be
second
possible.
week of January, my lord. Pray.
All right, the Land and Council for the state has produced the written instruction received from the Deputy IG of Prisons and DCS Odisha, and seeks some time to file the counter affidavit as per the order of this court dated 6/11/2023. Release this matter in the second week of January 2024. This is taken on record.
Item 18.
कौन कुहतु कौन हला
मामू घर सारे रेड करते
माइक एडजस्ट करंदु
मामू घर सारे रेड करथिली ता नानी घर आउ ता संग साथी सर पचारथिली के सर कोऑपरेट सर करनाते से झियर संग साथी के सर कोसंती ता सते कांटेक्ट रे के न आथिले
एफआईआर हेलानी
29 सर
केबे हला एफआईआर
27
28 ना 29
28
21 दिन में मिसिंग नोटिस
सो अक्यूज्ड कौन करे
से काम सर प्लांट रे बसला घरे को 2-3 मास करू सर घर
एका गाँव
आगे
accused family members को इंटरोगेट कलेनी
सर आनी सर थाना रे बसेथिली
आउ तार रिलेटिव्स
ता नानी घर को सर जाइथिली कोणिया अनुगुल जिला से आउ ता माउसी घर से सर कोणिया रे गुटे गां
फोटो आपण पार अवेलेबल अछि विक्टिम रो accused रो से लोकालिटी रे देखैथिले
ता नानी घर कोणिया सर जाइथिली ता नानी घर को जिया पर
ना नानी घर तो मना कर देथिबे आसी नथिले बेले
पर सर ताको साई पड़िसा जो पाटरे हम जाहा को पचालु ता घर कोडी ताको सर से फोटोटा देखैलु जे पिलाई गां को आस्थला ना कोन सर के मना
कले
ता माउसी घर भी सर से गां रे ता
कोडी छरा
से गुलंड सर अनुगुल जिला सर कोणिया
अच्छा
ता माउसी घर को जिया पूर्व सर ता घर हम पाइलुनी जाहा को पचालु ताको देखैलु सर फोटो से माने सर मना कले ना पिला आसीनी हम फोन सर तार स्विच ऑफ से दिन से डिया सर एनालिसिस करथिली जे तू स्विच ऑफ सर किछ आसीनी आ आई सर जो सर पकेजी ना सिम सर पकेले आसले सर रेस्क्यू
पिलार किछ बैंक अकाउंट
तीटा सर अछि गोटे कानारा बैंक रे सर गोटे एक्सिस बैंक रे
कोन अछि ता
से सर जिबार दिन पूर्व सर गोटे एक्सिस रु 1500 टका सर उठैथिला
हां
आ कानारा बैंक रो सर जा खाइथिला 28 तारिख केस रे जो दिन रात रे गला सर तापर सर कोन से ट्रांजैक्शन हैनी सर
नहीं
नहीं सर
घर लोक संगे अन्य कोनोसी फोन रु कथा वार्ता
बापा मारो ता भाई रो सर सीडीआर पके सर
अच्छा
मगे सर आसिले सर
किछि पॉजिटिव आसी नै ये आपण पर किछि इंफॉर्मेशन अछि
नहीं लॉर्डशिप
तो क्या करूं देखो सारथी देहुरी एएसआई of police Kamakhya police station is present and he has submitted a detailed report dated 4/12/2023 regarding steps taken for rescue of the victim girl and also to arrest the accused. Okay, right. The written report is taken on record. A copy would diun tango. Copy of the report has been furnished to the Learned Counsel for the petitioner. I assured this court that he may be given some further time to make necessary progress, to have some further progress in the case and take steps for rescue of the victim girl and to arrest the accused. List this matter in the second week of January 2024. I shall remain present on the next day and apprise this court about the development, if any, made in the meantime. Second week रे रहिला अपन जहा करिसेंदी आ भितरे थोड़ा ई करिवे एटा न्यू pre-copy of the order कर दे दे हाँ
Item number 19.
I prevailed this matter kindly within last 18th December.
Just a minute. Okay, last time it was the first day. Today is the second day. All right. The Learned Counsel for the state seeks some further time to apprise this court about the development regarding rescue of the victim girl, so also the progress of an investigation. Court of this matter in the week commencing from 18th of December 2020.
Item 20.
20 also I prevailed 18th December.
First date थी लगा सर आज second date. Same order कर देगा 18 तारीख को. Learned Counsel for the petitioner is present कर लिख दो है ना. ये रेडी हो जाए. 8 किस तरह बिल्कुल से ज़्यादा देर मैटर मोड Anybody present? Please come.
This is on private engagement, not through legal aid. Anyway, I am here to argue the matter.
Just a minute, let me see. No, initially, Mr. Das, perhaps one Hare Krishna Malik was engaged as the
legal aid counsel.
Yes, legal aid counsel as per the order of this court.
Yes.
That is dated 22/12/2018.
Yes.
Then how you entered appearance?
The client wrote from the jail
Prisoner's petition.
naming me and to disengage him. So that's
All
why.
right. So that is how you filed wakalatnama. Yes. Then you did not remain present on the last date.
Kindly
that is why. So now you are ready. All right. Give it. Mr. Tripathi, you will argue this one.
One PW6, the father of the deceased, lodged and information at the police station that his son deceased, namely my lord, he was missing from the last, went to get his wages from PW5.
Please come to the FIR.
Mr. Tripathi will conduct.
Okay, there is no problem.
Page 25.
25. May I place, my lord?
Just.
Page 25. Mu Duryodhana Kumura.
Is PW?
My lord, PW6.
Yes.
So and so, ଆଜି ଆପଣଙ୍କ ପାଖରେ ଉପସ୍ଥିତ ରହି ମୋର ଲିଖିତ ରିପୋର୍ଟ ଦେବା ଏଇକି ଯେ ମୋର ସାନ ପୁଅ ଧରଣୀ କୁମୁରା ଡାକ ନାମ ସମ୍ଭାରୁ ସନ୍ଧ୍ୟା ବେଳେ ଘରେ ଖାଇ ପିଇ ଆମ ଗାଁର କାଳିଆ କିଷାନ ଘରକୁ ତାର ମଜୁରୀ ବାବଦରେ ଟଙ୍କା ଆଣିବା ପାଇଁ ଯାଉଛି ବୋଲି କହିଲା। ମୁଁ ଘରେ ଥିଲା ବେଳେ
ଧରଣୀ is the deceased.
No, ଧରଣୀ is the deceased.
Okay.
କାଳିଆ କିଷାନ ଘରକୁ ଯାଇ କାଳିଆ କିଷାନ is PW5.
ଆଚ୍ଛା।
ଘରକୁ ଯାଇ ତାର ମଜୁରୀ ବାବଦରେ ଟଙ୍କା ଆଣିବା ପାଇଁ ଯାଉଛି ବୋଲି କହିଲା। ମୁଁ ଘରେ ଥିଲା ବେଳେ ଆମ ଗାଁର କାଳିଆ କିଷାନ PW5 ଓ ତାର ପୁଅ ବିଜୟ କିଷାନ PW1 ଆମ ଘରକୁ ରାତ୍ର ପ୍ରାୟ 7 ଘଣ୍ଟା 30 ମିନିଟ ଆସି କହିଲେ ତୁମର ପୁଅ ଧରଣୀକୁ ତୁମର ପଡୋଶୀ ଗୋବିନ୍ଦ ନାୟକ is the appellant accused ଓ ତାର ଭାଇ ଅଭିନାୟକ ଝଗଡା କରି ଗୋବିନ୍ଦ ଧରିଥିବା ଟାଙ୍ଗିଆରେ ଆମ ଘର ପାଖରେ
Abhinayak is
co-accused.
No, they both of them face trial.
Face trial. Abhinayak faced the juvenile court.
Okay.
And he is acquitted.
Okay.
And charge is 30234.
No,
and conviction is 302.
But assault part as for the FIR that is attributed against you. That Gobind
Govinda Nayak.
All right. ପଢନ୍ତୁ।
ହତ୍ୟା କରି ଦୁଇ ଭାଇ ଘଟଣାସ୍ଥଳରୁ ପଳାଇଛନ୍ତି। ଏ ଘଟଣା ଶୁଣି ମୁଁ ଏବଂ ମୋର ପୁଅ ଅଭି କୁମୁରା ଘଟଣାସ୍ଥଳକୁ ଯାଇ ଦେଖିଲୁ ମୋର ପୁଅ କାଳିଆ କିଷାନ ଘର
ଅଭି କୁମରା is
ଆଜ୍ଞା
ଅଭି
କୁମରା is the son of PW6.
PW examine ହେଇଛି କି?
No, not examine.
All right.
Not examine. ଘଟଣାସ୍ଥଳକୁ ଯାଇ ଦେଖିଲୁ ମୋର ପୁଅ କାଳିଆ କିଷାନ ଘର ପାଖ ରାସ୍ତା ଉପରେ ରକ୍ତରେ ଜୁଡୁବୁଡୁ ହୋଇ ମରି ପଡିଛି। ଗାଁର ଅନ୍ୟ ଲୋକମାନେ ମଧ୍ୟ ଘଟଣାସ୍ଥଳକୁ ଆସି ମୋର ପୁଅ ମରି ପଡିଥିବା ଦେଖିଲେ। ଏଣୁ ଆପଣଙ୍କୁ ଏଇ ରିପୋର୍ଟ ଦଉଛି।
Okay, eyewitnesses are there.
Yes, my lord.
2 eyewitnesses, PW1,
Just a minute.
PW9.
PW9.
PW1 and PW9.
Yes.
So PW1 is the brother of the deceased.
No. PW1 is the son of Kalia Kisan, PW5.
Yes.
Not. He says that
Kalia Kisan
whose house
all right. Right.
So
PW1
says,
please come to the evidence.
Yes, page 36, my
Just.
I know Duryodhana Kumura.
Wait. Yes, please.
Page 36. I know Duryodhana Kumura informant. I know the accused standing in dock. I also know Dharani Sambaru Bhoira Kumura deceased. The occurrence took place on 6/3/2007 in front of our house at about 7:30 p.m. At the relevant time, I was returning home. In front of my house, I noticed accused Govinda dealing axe blow on the backside of the head of the deceased Bhoira Kumara. I also noticed that he gave another blow by means of the said axe on his neck. As a result, he sustained bleeding injuries with profuse bleeding. I raised holla. Hearing the holla, one Raju Munda and Pradeep Naik appeared. They have not been examined. Raju Munda and Pradeep Naik appeared at the spot, and the accused Govinda, along with another Abhinayak, fled away from the spot. Thereafter, I, along with my father Dhaneshwar Kalia Kisan PW5, went to the house of deceased Bhoira Kumura and intimated the fact to his father and elder brother not examined on receipt of information. They rushed to the spot along with us. I page 37.
So he had seen two blows, one on the head, the other is on the neck, right?
Yes, my lord.
Yes.
Yes. I was examined by the police in this case on 6379. It is not a fact that I have not stated before the police that accused Govinda dealt another axe blow on the neck of Dharani. I was returning from the house of Swarnamunda at the relevant time. House of Swarnamunda is about half a kilometer from our house. By the time I was returning, my lord, darkness was approaching. Then paragraph 3. House of Lakshmi Kisan, Lima Kisan, Devanand Kisan, Bhukul Kisan, Mitra Kisan, all not examined now. Situated near my house. Houses of Bihari Kisan, Choynu Kisan situated in front of our house, which is intervened by the village road. On my arrival near our house, I noticed Dharani Kumar is actually deceased. Dharani Kumar is deceased. And one PW9 Lakshmana were talking with each other. And I also noticed accused Govinda and one Abhi coming near to them. While returning to our house from the house of my brother, I did not meet anybody on the way. House of deceased is situated about half a kilometer away from our house. So also the house of Govinda accused and Abhi situated in a similar distance from my house. Houses of deceased as well as Govinda and Abhi are adjacent. Thereafter other houses of our village in between the house of deceased accused and our house. Our new house which was under construction is at a distance of 400-500 feet away from our old house. Houses of Rupan Munda, Sakra Naik, Dhanurjay Munda and others are situated near a new house under construction, not been examined. Then paragraph 4. I noticed the assault on Dharani by Govinda from a distance of 10 to 15 feet. Hearing my holla, at first Raju Munda, then Pradeep Naik arrived at the spot. In 5 minutes. Tangia axe is commonly available in each and every house of our village. Our village road runs from north to south. Houses of Rajumunda situated near our newly constructed house, and the house of Pradeep Naik is at a distance of half a kilometer away from our house in the same direction. I have read up to class 6. I have no idea regarding the direction. Houses of Pradeep and Raju situated in the opposite direction of the accused, and our house is in the midst of it. It is not a fact that at the time of my arrival near my house, many of our villagers were assembled on the road. It is not a fact that I have not seen the assault by Govinda to Dharani by means of axe on his head as well as neck. It is not a fact that I am deposing falsehood against the accused due to previous enmity standing between our family and accused regarding transaction of money for construction of our new house. It is not a fact that I have not raised holla and that hearing the same Raju and Pradeep appeared at the spot. This is PW1, my
So
lord.
how do you challenge the evidence of this eyewitness?
My lord.
Except one line which you have elicited in the cross-examination that it's not a fact that I have not stated before police that accused Govinda dealt another axe blow. That means the second blow which you have stated, whether that has been not brought out, proved through the investigating officer.
Yes.
Is it been proved?
No.
ताले ये सजेशन न मूल्य कौन रहला बा जो प्रीवियस स्टेटमेंट कन्फ्रंट करले ताको प्रमाण करियार दरकार थला आईओ पाकु जदी आईओ पाकुरु ये करना तमन से स्टेटमेंट कहिची so how do you disbelieve why we will disbelieve this eyewitnesses account? What is your submission?
PW1.
Yes.
And if my lord would see kindly the PW9, another eyewitness, PW9 excludes the presence of PW1 on the scene of occurrence. Both are eyewitnesses.
No, no, kiye kouti thibo dekhibo je is it possible?
No, PW9 was very much on the scene of
ସନ୍ଧ୍ୟା ହେଇଗଲାଣି ମୁଁ ଫେରୁଛି ମୁଁ ଯାହା ଦେଖିବି ଆଉ ସେଠି କିଏ 5 ଜଣ 10 ଜଣ ଥିଲେ କିଏ ଥିଲେ ମୁଁ କହିବାକୁ ଇଜ ଇଟ୍ ପସିବୁଲ ଅନ୍ ମାଇ ପାର୍ଟ ଦ୍ୟାଟ ଆଉ କିଏ ଥିଲେ ଘଟଣାଟା ହେଲା ମୁଣ୍ଡରେ ରହିବ ମୁଁ କାଳେ ମତେ ମାରିଦେବେ ମୁଁ ଖସି ପଳେଇବି କେମିତି କିଏ ସେଠି ଉପସ୍ଥିତ ଥିଲେ ଇଜ ଇଟ୍ ଏ ଗ୍ରାଉଣ୍ଡ ଟୁ disbelieve that he is not stating about the presence of let us say PW is not stating the presence of another eyewitness PW5. Can
One.
that be a ground to disbelieve the evidence of PW5,
Not
or his
on.
presence would be doubtful on
Yes.
either of these grounds?
Yes, on.
So, obviously, these type of questions are being asked. Say, locality जो जागा पाखे कहा का घर ना ये मान घर से माने कहीं एग्जामिन हेलानी ये तो लोकटा बाहर लोक जाउथिला ये कहीं एग्जामिन हेला कि से माने तांको घरे थिबे से माने प्रेजेंट थिबे कि नाही से माने साक्षी देवा पई प्रस्तुत थिबे कि नाही. So many things arises for consideration. So that cannot be a ground that merely because the houses of other persons they are nearer the house, that cannot be a ground.
And my lord, they have not appeared in the scene. Other houses, the inmates, they have not come. Distant place is the Rajumuna and Pradeep Naik. PW1 says, hearing holla.
ଗଣ୍ଡଗୋଳ ହେଲେ ଲୋକ ଘରେ ଦେଇ କବାଟ ଦେଇକି ଚୁପଚାପ ରହିଯାଉଛନ୍ତି. ଆମେ ବାହାରିଲେ ପୋଲିସ ଆମକୁ ଛାକି କରେଇଦବ.
ଏଇ ଦି ଜଣ କିନ୍ତୁ ଆସିଲେ ଦୂରରୁ.
ସିଏ ପାସ୍ କରୁଛି
You
ଆଜ୍ଞା.
do not know the conduct of a person, how someone will behave in a particular situation. How can we gauge it? Some people may close the door, some people may come forward.
Yes.
And these two persons, they have not been examined. Rajimunda and Pradeep, though it is examined by the police, but in the court, they have not been examined.
No, he has given it, you see, in the first line, the occurrence took place on so and so. I was returning home and in front of my house this year. ତେଣୁ ସେ ଘରୁ କୁଆଡେ ଯାଇଥିଲା ଏବଂ ଆପଣ ପଚାରିଛନ୍ତି କ୍ରସ୍ ଏକ୍ସାମିନେସନ ରେ କୁଆଡେ ଯାଇଥିଲା ବୋଲି ସେ କହିଛି ପରା.
I was returning from the house of Swarnamunda.
ହଁ ଆପଣ କହିଥାନ୍ତେ ଯେ ସ୍ୱର୍ଣ୍ଣ ମୁଣ୍ଡାକୁ କାଇଁ ଏକ୍ସାମିନ କଲାନି, ସେ ତା ଘରକୁ ଯାଇଛି କି ନାହିଁ କହୁଛି ଆପଣ.
Half a kilometer distance.
Yes, that is also disclosed.
ଗୋଟେ ଲୋକ କେତେବେଳେ ଯାଇଥିବ କୁଆଡେ ଯାଇଥିବ ସେ ଜାଗା ଦେଖିକିନି ଇଏ ନା ଖାଲି ସେଇ ଲୋକାଲିଟିର ଲୋକ ହିଁ ସାକ୍ଷୀ ଦେଲେ ବିଶ୍ୱାସ ହବ, ଯିଏ ଆସୁଛି ସେଇ ରାସ୍ତାରେ ଯିବାର ଯାହାର ମାନେ
Yes, chance witness is-
ଆସିଲା ବେଳକୁ in front of his house this occurrence has taken place.
Yes, exactly.
In front of his house.
There is no dispute that the place of occurrence is in front of the house of PW1. So his presence at that spot at the relevant point of time is very probable, and he has stated that while I was returning. It's right that he has stated that the house of other persons are also there, and it is also right that they have not been examined. Right, but can that be a ground? We are now putting a question, can that be a ground to disbelieve the evidence of PW1? Jodi nahi, to ei jo evidence taku jodi apna discard kari pari nahanti, ebong ei evidence taku accept hobo, the manner in which you have dealt two blows, one on the head and on the neck, whether it is getting corroboration from the
Yes.
PM report or not. Let us go to that. Then we will come to the other eye. Who is the PM doctor?
PW8.
It's 53, man.
Padihle.
On 7/3/2007, I was working in the same capacity. On that day, on police requisition at 12:50 p.m., I held autopsy over the dead body of deceased Dharani, so and so, and external appearance. The dead body is of a young man aged about 30 years, average body build with nutrition.
Come to the next.
External injury.
Yes,
Next
external injury. Yes. Lacerated injury wound of size so and so over left occipital-temporal region of the scalp, 1 inch back to left ear, and lacerated wound of size 3 inch into 1.5 inch in 3 inch present just below chin, extended laterally on the right side up to middle of the neck, which is present transversely. On dissection, I found fracture of part of occipital and temporal bone of the skull below that region. There is laceration of brain matter, bleeding inside the cranium cavity present. Cause of death is due to hemorrhage and shock as a result of injury to vital organ like brain and injury to the large vessel. All the injuries are antemortem in nature and sufficient in ordinary course of nature to cause death of a person. Time since death is 16 to 24 hours at the time of postmortem examination. This is the postmortem report March 11.
Then police requisition, he received that axe which was seized. and with a handle portion.
Examine the produced weapon of offense. One axe with a wooden handle wrapped by plain paper, the description of which is made of a solid part made of iron with a wooden handle inserted to the hole. Length of solid part of iron portion is 5 inch. It has a sharp cutting edge whose length is 2.5 inch, blunt and 1.5 inch. Solid iron part contains some unknown stain which is looking like a dried blood. The length of the wooden handle is 27 inch and circumstances 3 inch. It is broken slightly at the lower end. On my examination, I opined that the injuries found in my postmortem report can be possible by the produced axe. After examination, I sealed the weapon, labeled it and handed over it to the accompanying constable. This is my query report, marked so and so is my signature. This is the axe which I examined, marked MO1, cross-examination, page 55. I received the axe which was wrapped by paper but not sealed. I had affixed a paper slip, putting my signature over the seal. I put a paper slip on the iron portion of the axe as well as on the seal, but my signature does not appear on the paper slip affixed on the iron portion of the axe which I examined. By the time I received the axe, there was no paper slip affixed either on the wooden handle or on the iron portion of the axe. Incised wound can be possible by the sharp side of an axe. Lacerated wound cannot be possible by the sharp side of the axe, but is possible by the blunt side of an axe. The injuries which I found over the dead body of the deceased cannot be possible by one fall against a rocky surface or a blunt object. External injury number 1 can be possible by a single fall against a hard, blunt, or rocky surface. It is not a fact that I have not examined the weapon of offense, axe MO1. It is not a fact that I have not properly conducted postmortem examination over the dead body of the deceased.
So what we have got from the two injuries which are deposed to by the eyewitness PW1. We have one is on the head, that is there. The other injury is on the neck, that is also there. The weapon of offense, he has stated the axe. Axe was seized, produced. The IO has examined, and he said that I opined that the injuries found in my postmortem report could be possible. So that means the ocular evidence corroborates the medical evidence.
I will submit one line before your lordship. When a doctor says, and also two other witnesses, they have said that by the sharp side blow was given, my lord. Only incised wound is possible. So lordship may kindly see the injuries are all lacerated injury.
No. You see PW1 evidence. I noticed accused dealing axe blow on the backside of the head. I also noticed another blow of the sword on the so and so. He sustained bleeding injury so and so. So where he has stated that sharp side was used, PW1.
No, other witnesses have done.
PW,
yes. No, PW. Doctor has said it is possible by the sharp side. Yes. Doctor has said that. Now other witnesses have not.
No. Doctor kon koile?
Doctor koile, incised wound can be possible by the sharp side of an.
It depends upon the part of the body where that injury is caused. You see, Modi's jurisprudence will find that if it is caused on a hard surface like head, it may sometimes appear to be a lacerated looking injury. It depends upon the कारण एठी जोड़ा हबो ना एटा पचकिन कटि जीवो एठी हेले ताको ब्लॉक करिवो. So that is how it is stated. Sharp side use हेले मध्य the appearance would be एठी जो injury टा हबो एटा पूरा cut inside wound जो type र हबो मुंडरे हेले से type र हबो नि. Depends the part of the body where it is. You can examine it, Mr. Tripathi. See that if a sharp cutting weapon is used, incised wound au ye clearly achi Modi's jurisprudence re jad head re jodi habo, it may sete sharp habo ni mane ye re block karibo taku. फ्रैक्चर आसीबो जोटा कि हेछि केस फ्रैक्चर
All
हे
is fractured.
बट एठी आपण जो टाइप रो इंजुरी टे देबे
Cut injury.
गोटा जोटी माने आपण करो स्किन
Flesh
पोर्शन
अछि.
अछि से
Flesh अछि जोटी.
सॉफ्ट पोर्शन अछि सेठी पूरा एकदम आसीबो शार्प ये सो এইটা जो आपण एलिसिट करछि ना एटा जनरली कहूछि जे इनसाइज वुंड कैन बी
Yes, yes.
पॉसिबल so have you given a suggestion that this injury which you have noticed is not possible by the sharp side of this have you put any
No.
question he has already answered in the
Yes.
chief examination you want to discredit him so you must bring it to the note आपण ओडे जनरली पचार देले से कहला जे इनसाइज वुंड गुडा को शार्प साइड रो ठीक कथा एटा तो पाठ भी से आगो but is it
Our case.
your case that this particular injury is not ताको attention आपण draw करिवे एवं attention draw करिया गला आपण authority देखैबे जे देखंतु मोदी या कहउछन्ती टेलर या कहउछन्ती हां आपण केमती कहि देउछन्ती ये करिया सो in unless that questions are put in that manner खाली गोटे लाइन नै आइले जे इनसाइज वुंड एथेर हबो ता द्वारा सी लैसरेटेड वुंड देखिला सेटा डिसबिलीव हे जीवनी जे so in worst case also let us say that sharp side कई कहि नांती एवं ये यूज हेछि माने ब्लॉन्ड साइड हेछि मारला बेले होय तो बुली जाइथिबो जहा भी हो but how do you at least the head injury which is responsible that is sufficient in ordinary course of nature to cause death the other injury is also there and the impact is such you see the fracture of occipital temporal bone
Brain
is
matter has
there
come out.
and brain matter came out and then specific opinion is that it is sufficient in ordinary course of nature so the part of the body you selected the manner of assault and the impact it has
Right.
caused with the opinion of the doctor so and what the other witness says
PW9.
let us the other eyewitness
Yes, ma'am.
PW9 let us come to that
Page 56, my lord.
yes please place it
I know the accused standing in dock. I also know deceased Dharuni Kumura. The occurrence took place on the Tuesday on 6th day of month 1 year and 1 month back at about 7:30 p.m. On that day morning, I along with accused Govinda and Dharani Kumura deceased had been to the construction work of the house of Kalia Kisan. At about 5 p.m., I along with Govinda and deceased Dharani went to the house of Kalia for our payment. I entered into the house while Govinda and Dharani were standing outside. As Kalia Kisan refused to pay money as he was not having changed money, I came out from his house and then I along with Govinda and Dharani went towards Tolopada of our village. While returning back to the house of Kalia, on the way Dharani seeing the aunt of Govinda, namely Jama, asked her to provide khoini. At this a quarrel ensued between Govinda and Dharani and leaving them, I went to the house of Kalia for payment. And on my return, I did not notice Govinda there. Govinda is appellant. At that time, while I, along with Dharani, were talking near the electric pole, where one electric bulb was burning, at about 7:30 p.m., I noticed Govinda holding an axe, along with Abhinay, suddenly arrived there and dealt axe blow on the backside of the head of Dharani, and thereafter dealt the second blow on his right side neck. As a result, he fell on the ground with profuse bleeding. Thereafter, seeing the assault, out of fear, I fled away from the spot.
that means this man has seen right from the beginning
Yes.
that
He was along with that.
He is the pre-occurrence witness also. He was
no, for some time the appellant went somewhere
yes.
but he came again holding that axe
Yes.
Along with the other co-accused who was a juvenile face trial got acquitted Then first blow Dharani who head ray, second blow neck,
Neck ray.
which is the also the version of PW1.
Then cross-examination.
Yes.
I was examined by the police on 6th night at about 11 to 12 p.m. I cannot say the month of occurrence, so also the year. Dharani asked for Khoini to Jama near the house of Kalia Kisan and Bhukul Kisan. Houses of Manu Kisan, Mitra Kisan, Bihari Kisan are situated near the house of Kalia Kisan and Bhukul Kisan. By the time Dharani asked for Bhango to Jama, none except Govinda and myself was present there. It was then 7 p.m. House of Govinda situates in front of my house. Kalia Kisan did not come out from his house. Kalia Kisan is the father of PW1. Did not come from his house with me. I was talking with Dharani standing in front of the house of Kalia at about 7:30 p.m. Save and except myself and Dharani, none was present there at that time. It is not a fact that other villagers of our village have noticed us talking there. It is not a fact that Govinda and Jama did not return again to the spot. I cannot say the reason for which a quarrel ensued between Govinda and Dharani before the occurrence, but I heard that Dharani and Govinda were engaged themselves in a quarrel, and thereafter Govinda took his aunt Jama to their village, to their house. I have not seen any other person when Govinda and Abhi came towards us holding the axe at that time of assault on Dharani. I was standing at a distance of 3 feet from them. Seeing the assault out of fear, I ran towards my house, and after my arrival in house, I narrated the incident to my father in our house while running towards my house. I had not noticed anybody of our village on the way. I have also not seen any other person in and around the spot. It is not a fact that I am deposing falsehood against the accused, as I was not pulling on well with him and his family members. It is not a fact that I have not noticed assault on Dharani made by accused Govinda on his head and neck. Budia is commonly available in each house of our village. It is not a fact that Dharani dashed against stone and thereafter against the electric pole and sustained injuries on his head and neck and died. It is not a fact that I have not seen the occurrence and that I am deposing falsehood against the accused Govinda assaulted Dharani by the sharp side of the axe to his head and neck.
No, this statement, it as such, you cannot.
Independent of both.
This statement cannot falsify the presence of PW1. এই যেটা কইছেন না, I had not noticed anybody of our village on the way. I have also not seen any other person in and around the spot. এইটাକୁ ଆପଣ it is
And what I beg to submit before your lordship, PW1 raised holla. Raising of holla is also not said by this another eyewitnesses. PW1 was there. He went to his house and his father is PW5 where they were all working. He was inside and in front of their Danda Rasta while the occurrence took place. PW5 Kalia Kisan has not come outside, but Kalia Kisan came subsequently, went along with the PW1 to the house of the deceased and said that your son is dead, is killed. And your lordship may can say PW1 went to his house, narrated before his father. His father is also not examined.
No, you want that in a 302 case, how many witnesses are required to be examined to prove the case? 134 of the evidence, it says about the quality of the evidence, not the quantity.
Evidence to be counted.
ପ୍ରତ୍ୟେକକୁ ଆପଣ ଲିଙ୍କ କରିବେ, ସିଏ ସେଠିକି ଯାଇଥିଲା ଆଜ୍ଞା, ତାକୁ ଏକ୍ସାମିନ କରିବେ, ଏଇ ଲୋକାଲିଟିରେ ଏଇ ମାନଙ୍କ ଘର ଥିଲା, ସମସ୍ତଙ୍କୁ ଏକ୍ସାମିନ କରିବେ, ତାହେଲେ ତ ଗୋଟେ ଚାର୍ଜସିଟ ରେ ୱିଟନେସ ସଂଖ୍ୟା 100 ହେଇଯିବ ମିନିମମ। ହଁ, ତ ଏଠି ଯେହେତୁ କହୁଛନ୍ତି କ୍ୱାଲିଟି ଅଫ ଏଭିଡେନ୍ସ, ଆପଣ ଆଗେ ଯେତିକି ୱିଟନେସ ଆସିଛନ୍ତି 2 ଜଣ ସାକ୍ଷୀ, ତାଙ୍କୁ ଆଗେ କଣ ପାଇଁ ଆମେ ଡିସବିଲିଭ କରିବୁ ତାକୁ କଥା କୁହନ୍ତୁ। ଆପଣ କହୁଛନ୍ତି ସିଏ ହେଇନି, ସିଏ ଅମୁକ ହେଇନି, ସିଏ ଯାଇକି ତାକୁ କହିଥିଲା ସିଏ ହେଇନି। ଦିଜ୍ ଆର୍ ଅଲ୍ ହେଇନାହାନ୍ତି, ଠିକ ଅଛି ହେଇନାହାନ୍ତି, ବଟ୍ ଯୋଉମାନେ ହେଇଛନ୍ତି ତାଙ୍କର if their evidence and when the law is that even on the basis of the evidence of a solitary witness, if it is clinching, trustworthy, so that can be
cogent and trustworthy.
So now if the evidence is getting corroborated by another witness, the part of the body where you have assaulted, that is also corroborated by the medical evidence. So merely because some witnesses, and another thing, yes, there was some quarrel, but that was not a quarrel of that nature. And you went to your house, collect that axe, came to the spot and started assaulting, selected the body part, assault, head, and then so कौन की माने गोटे सडन क्वारल सेट कोन गोटा पड़ची अमक के आपण आदुर
spur of the moment,
से गोटा पार that's a different matter.
Since there is time to get reflection and
right.
your lordship is right. जाइकि आसला भाबिला केते कथा चिंता करी पार न
जाइकि आसिकिन आपण कंडक्ट होची को पार्ट रे सिलेक्ट करछन ताकू मध्ये सिलेक्टिवली दीटा प्लेस को जोटा की बॉडी रो सबटू वन ऑफ द वाइटल पार्ट्स हेड ऑन नेक रे शार्प कटिंग वेपन यूज करिके मारछंती fracture एठी होची नेक इंजुरी होची
PW1 says is
sufficient
not attributing any motive, nothing is attributed. Suddenly person Govinda appeared, there is no previous enmity, nothing else, no motive. Suddenly he came, appeared in the scene and gave
He might have seen that part. He might have seen that part by the time he came with holding an axe. So previous part is taken by PW9.
No, PW9 what happened, my lord? This PW9 and
Mr. Das, many decisions are there that when direct evidence is there, no motive is necessary to be proved. Se motive, weak motive hele bi chalibo. Apanakara circumstantial evidence hele motive assumes significance. But when direct evidence is there, so motive, a motive re kon pai prosecution. Tapare motive is there in the mind of a person. It's very difficult for others to know why he has committed the crime. So it's not also, that is why I exactly said that direct evidence देखुची मारची ता सामना रे आमे surrounding देखिलु corroborating evidence asla medical evidence. So how do you be successful in disbelieving the evidence of those two witnesses 1 and 9 coupled with the medical evidence of PW8? Doctor 8 na?
Doctor 8.
8, right.
then next date
काली कंटिन्यू करियो
आज्ञा
काली कंटिन्यू करिवा
मु गोटे छोटो प्रेयर करिवि काली आसी in fact I am mourning and observing my cousin brother has expired
ना हमें तो आज सार दी था तो केस हमें काली टाइम नहीं because
tomorrow
so let us
ठीक है tomorrow
he is on bail
he is on bail but after 10 years he was released.
No, it's all right, but
10 years inside.
You search for, maybe you may get some point or not, that's a different matter. But whatever you placed, that nothing has been brought out in the cross-examination, we find, to at least disbelieve the evidence of these two witnesses. But you again read the evidence, you may get something from the...
Yes, tomorrow.
And one thing just keep in mind, let us say, you said that, suppose it is proved that in a case that a person is having a sharp cutting weapon, like axe, but he is not using that sharp side, he is using the blunt side, giving two blows. Let us go to that. That what will be its effect? Whether 302 will be there or it will be lesser offense. That part also you examine. Okay.
Pardon,
My lord. My lord, 151, kindly taken up today, my lord, with you. 151.
pardon, Lordship. Lordship, item 221, Lordship. I have filed an interim appeal of condonation of delay, Your Lordship. Last one, Lordship, directed to filed objection, Your Lordship. My Lord Senior filed the objection at flag D, Your Lordship.
$221.
221.
It's a case of conviction or what?
Yes, Your Lordship. Convicted under section 20B 2CF TCF NDPS Act, and out of 10 years, appellant was in custody 8 years, 7 months, and 24 days, Your Lordship.
Oh, delay is 1978.
Yes, Your Lordship.
Five years. What is the IN number? 2057.
Yes, Your Lordship.
IN number 2057 of 2023. Number item number लिख लेता serial number ना 221 ना IN number 2057 of 2023. This is an application for condonation of delay. The stamp reporter has pointed out that there is delay of 1978 days in filing this criminal appeal after going through the averments taken in the interim application and objection filed by the learned counsel for the state. And since the appellant has been sentenced to undergo RI for 10 years, I'm inclined to condone the delay. Accordingly, delay is condoned. IA is disposed of. Hard admit. Call for the trial court record. IA number 2059 of 2023. The learned counsel for the petitioner submits that the petitioner is in judicial custody since 11/4/2015, and as such, he has already undergone 8 years and 7 months of sentence out of 10 years imposed by the learned trial court. Let the learned counsel for the state produce the custody certificate from the concerned jail superintendent on the next date for consideration of the bail application. Free copy of the order be handed over to the learned counsel for the state.
Which jail?
Oblige, Your Lordship.
Jail.
192 pilot on the last occasion, custody certificate was
Just
therefore the petitioner is in custody.
wait. এটা কেতে নম্বর গলা item 2 delay condoned admit yes, which number, Mr. Das?
203. On earlier occasion, my lords asked the state council to obtain antecedents.
Please say bail matter. Criminal appeal
Yes,
in bail. Okay, you bring that file, see whether you have brought it or not.
I think 185 million. Out of 10 years, 9 years he is in custody. I have obtained the custody certificate from
Call it.
I mentioned earlier.
Mark it. Okay. Yes.
My lord, I may be pardoned.
And out of 10 years, he is already in custody 8 years, 7 months.
You have got the custody certificate. Mark it.
19. Lordship.
Yes.
Lordship, weekly list, item number 121, Lordship.
Hmm.
In this case, Lordship, the petitioner's wife's health condition is serious, Your Lordship, for which we have filed an interim application.
121. So, which is that particular IA?
IA number 2947 of 2023.
That has not come on record today. So, IN, that is CRLN number 1036 of 23.
Yes, Your Lordship, today we have filed this interim application.
Oh, what is that IA number?
IA number 2947 of 2020.
Have you served a copy on the State Council?
Yes, Your Lordship.
All right. You take instruction, wife's ailment.
Yes, Your Lordship, wife's health condition.
The item number 121. The Learned Counsel for the petitioner submitted that today he has filed an interim application for interim bail on the ground of ailment of the wife of the appellant, which is registered as IN number 2947 of 2023. And it is further stated that the copy of the interim application has already been served on the Learned Counsel for the
Now he is
as a served in court कर दिया है ना? Learned Counsel for the state seeks some time to obtain instruction on the interim application. Place this matter in the week commencing from 18th of December 2023.
May I
May I
to mention item now 231, my lord.
Yeah.
Earlier, that is mentioned by the lord.
Wait.
Mr. Deep, it will be taken up.
231.
One
Huh?
minute.
Is a OPID Act
Please,
matter.
ma'am. Last.
So where is Mr.
We need intimation.
Mr. Patra and Mr. Bhuiyan?
I will intimate Mr. Bhuiyan.
Okay. Just mark it, note it.
May I please, Your Lordship? Your Lordship, CRLA number 314 of 2018. This is for the release of seized article. It was adjourned on 15/5/23 and it was to come after vacation. It has not come up till now.
Give it.
Kindly.
Just a minute. Wait. '91 is JCRLA number 53 of 2017. What do you say? No. What is the sentence imposed?
10 years, 22B, 2C of NDPS actually.
How many years you are in custody?
8 years, 1 month.
So, in number to mark kari rakhun. All right. Yes. Any mention from?
My lord, item 90, my lord.
Yeah.
My lord, out of 10 years, my lord, he was in custody since 2014.
No, have you got that
Near
custody
about 9.
certificate with you?
That was called for since long. After that, my lord, your lordship has
Okay,
granted interim bail
Mr.
to him and surrendered.
Tripathi,
My lord.
item number 90.
My item.
Please, wait. 90 रे custody certificate मगाई चला फाइल मगेइन देखो तो आश्चर्य नहीं मार्क करो
25/4
all right yes Miss Tripathi make your submission please unmute yourself.
Last occasion, my lord directed to London State Council to obtain the custody certificate, my lord. In this case,
which is the item?
My lord, 208, my lord. Ten years conviction.
Wait.
10 years.
208.
My
yes. What sentence has been imposed by the London Trial Court?
10 years, my lord.
And what sentence you have already undergone?
Now, my lord, he is now in custody since 2018. This is, my lord, about 5 years or 6 months, my lord, till now.
अच्छा এইটার custody certificate মগাইতলা দেখুন তো আসছে না নাই item number 208 mark it. Okay, I'm marking it.
My lord, God bless.
Item 125 can taken up today, man.
Why?
I'll be miscase for interim order, interim release, my lord.
Interim bail.
My lord.
On what ground?
The ground of medical health, my lord.
କାହାର?
Mother aged
ଆଗରୁ ଆସିଥିଲା ନା first time ଆସିଛି?
ନାଇଁ ଆଗରୁ ଆସିଥିଲା.
Whether the state council was asked to obtain instruction or it is coming for the first time?
It is for the first time, my lord.
Okay, so we obtain instruction. That is 125.
ଦେଇଛୁ the high copy.
ହଁ copy ଦେଇଛୁ.
Weekly list item 125. IA number 2493 of 2023. This is an application for interim bail on the ground of ailment of the mother of the appellant. Learn and counsel for the state seeks some time to obtain instruction on the interim application. List this matter. We commencing from 18th of December 2023.
Obliged.
Yes.
Supplemental list item number 1.
Extend the time.
2.
Extend the time.
3.
Yes.
Here, a petition was moved for representation of the appellant under 205. He was issued with summons, my lords, on having been charge sheeted under sections 294, 323, 341, IPC and 32VA of the SC and ST.
341, 323.
Aye.
32 VA.
Aye.
Okay. So
my application for representation is based on the ground that I am a doctor in government service and that appearance on each day was not necessary.
what is the allegation against you?
Allegation is that the informant, she was a Asakarmi, she had brought a patient for labor to the headquarters hospital and I had allegedly assaulted and abused.
During investigation, 41 and notice
Yes,
was
my
served.
lord, 41 notice was served.
Why it was rejected? Why it was rejected?
He says, my lord, that granting of 205 will amount to a blank check. My lords may look at page 13. The court writes, from the record, it is noticed that accused is a medical officer.
Yes.
Nowhere it is mentioned that the accused is busy for round the clock in her profession. It is found from the petition filed under 205 that learned counsel had sought this application on many grounds, which is mentioned in the petition, but counsel has not supplied any single evidence to prove averments as per facts mentioned in 205 here. Hence, court is of the considered view that granting blank check under 205 CRPC affects process of this court about framing of charges and other proceedings in which presence of accused is highly essential, but it is not clearly proved about facts and averment mentioned therein. I had undertaken, my lords, that whenever my personal attendance is necessary, I would have. And so far as the other averment that I am busy round the clock, I am a gynecologist, my lords. I am to attend deliveries whenever the patient goes into labor. And it can't be guaranteed that the patient will go into labor only after court hours.
Yes. Any citation you want to rely?
Yes, there is one judgment of your lordship, my lords.
Technical grounds.
Your Lordship may see this.
SC/ST Act दिवे one of the offense is 3-2 VA.
Yes, Bill.
Yes, Mr. Mishra.
Lordship.
What do you say?
Lords, Section 205 provides a discretion to the magistrate, Your Lordship.
Hmm.
That when the grounds are reasonable, then only he can dispense with the personal appearance of
So
the
she is a government doctor.
Lordship.
And lady.
My lords.
And during investigation also, you did not think it proper to arrest her. So 41 a notice was served on her.
Yes.
Now he is ready to give an undertaking that he will appear as and when necessary. And these offences are very minor offences. This under which the charge sheet has been submitted. That is 341, 323. And 32 VA says that whatever punishment is there for that offense, that will be this one. The same. That means its maximum is 1 year. देखिए आई पिस्टा देखिए
341 simple imprisonment for 1 month or fine of 500 rupees.
323 टा 323 टा बोले 1 year अच्छी 1 year था इपर
Imprisonment for 1 year, fine of 1,000 or
1 year. So this is all right. This CRLA has been filed under Section 1482 of the SC/ST PO Act 1989, read with Section 482 of the CRPC, challenging the order dated 28/8/2023, passed by the London Special Judge Bhavani Patna in city number 1064 of 2021, bracketed Special Act, in rejecting the petition under Section 205 CRPC filed by the appellant Dr. Hemangini Meher to dispense with personal appearance. The case was instituted on the basis of written report presented by one Sangeeta Naik
Annexure 2 is there.
before the inspector in charge
Town PS
of Bhavani Patna Town Police Station, Bhavani Patna Town Police Station on 30/9/2021, and accordingly case under section 294, 341, 323 of the Indian Penal Code was registered, and in conclusion of investigation, charge sheet was submitted on 23/2022 against the appellant under section 341, 323 of the Indian Penal Code, read with section 32 VA of the SC/ST PO Act. The prosecution case, in short, is that
Page
on
25.
on 30/9/2021 at about 9 a.m., where the informant was coming from T.H. Rampur along with one pregnant lady, Kiramani Jharia, to DHS Bhavani Patna, at that time the appellant asked the informant as to how many times she came to the hospital from T.H. Rampur. On hearing the same, the informant replied that since last 1 hour, and then out of sudden provocation, the petitioner, the appellant, alleged to have assaulted the informant by means of fist blows,
No, a slap.
slap,
Page 25, your lordship may see
uh,
the facts
slap, and abused her. During course of investigation, the investigating officer with the SDPO Sadar, Bhavani Patna, served notice under section 41A of CRPC on the
9/10/2020.
9/10/2020 on the
2021
on the appellant, and ultimately, on conclusion of investigation finding prima facie case, the charge sheet was submitted. The appellant filed petition under section 205 CRPC inter alia, taking the grounds that she is a public servant and used to attend the public duty in all emergency and non-emergency cases, and her attendance in public field in attending the patient is essential, and therefore her personal appearance may be dispensed with. It is further stated that the appellant may be allowed to represent it through her counsel, and appellant undertook to appear as and when her personal appearance would be needed. The Lennon trial court in the impugned order held that nowhere in the petition it is mentioned that the appellant, being a medical officer, was remaining busy for round the clock in her profession, and no single evidence has been supplied to prove the averments taken in the petition under section 205 CRPC, and therefore allowing the petition under section 205 CRPC would be like granting blank check, which would affect the process of the court regarding framing of the charges and other proceeding in which the presence of the appellant would be highly essential. Accordingly, the petition filed by the appellant was rejected. Mr. Devasis Pandal and counsel for the appellant contended that the offences alleged are not serious offences, and the petitioner is a lady, and she is a government doctor, and she is a gynecologist, and
Specific
she-
averments were made at para 3 of the petition.
And-
Annex 4, page 26.
and specific averment has been taken in the 205 CRPC petition as to how she used to attain her public duty in emergency as well as non-emergency cases, and her attendance in public field is very much necessary, and therefore in a case of this nature it would not have been proper for the Learned Trial Court not to allow the petition, particularly when undertaking has been given by the appellant to appear before the Learned Trial Court as and when required. The Learned Counsel relied upon the decision of this court in case of Benjamin Raul versus Sajil Das, reported in 2017 volume 2 ILR Cutter 964. Mr. Shonok Misral and counsel for the state, on the other hand, supported the impugned order. (205) CRPC deals with the power of a magistrate to dispense with the personal attendance of the accused. Subsection 1 states that at the time of issuance of summons under section 204 CRPC, if the magistrate thinks that the personal attendance of the accused is not necessary, he may dispense with such personal attendance and permit him to appear by his pleader. No doubt, section 205 CRPC does not specify as to in which cases the magistrate can pass the order for dispensing with personal attendance of the accused, and it gives complete discretion to the magistrate. But the wording in that section, if he sees reasons so to do, inverted comma vitere, obviously doesn't mean unrestrained exercise of choice, or will rather it must be done with sound discretion, that is with knowledge and prudence, and the magistrate must pass a reasoned order. The power under section 205 CRPC has to be exercised in regard to the circumstances of the case, condition of the accused, the necessity for his personal attendance, etc. In the case of K. Narayan Patra versus Gopinath Sahu, reported in 1991 for OCR 486, it was held that courts should be generous in exempting accused from personal appearance. Such appearance is the rule in criminal cases of serious nature involving moral turpitude and punishable with imprisonment for some length of time. Court has to weigh inconvenience likely to be caused to the accused if he is required to be absent from his vocation, profession, trade, occupation, and calling for attendance in court, against prejudice likely to be caused if he does not appear in court. Yes. Whenever personal attendance is insisted upon, there is indubitably some harassment to the accused, and the courts have to see that this harassment is not out of proportion to the seriousness of the allegation, the severity of possible punishment on conviction, nature of allegation as they stand out prima facie. Courts should normally dispense with personal appearance when it concerns with a Pardhan Sin woman, highly placed public functionary, busy captain of an industry, and persons rendering public service. In case of Kamaljit Singh Alwalia versus State of Orissa, reported in volume 85, 1998, Cuttack Law Times 372. This court has been pleased to hold as follows. Quote here from this. In the case of Benjamin Rao, bracketed Supra, this court was considering the rejection of the 205 petition of an accused in a case under section 406 of the Indian Penal Code. And after discussing the law laid down, it has been held that the London magistrate has neither taken the social status of the petitioner, his age, nor necessity of personal attendance. And after considering the nature of accusation in the case, the London magistrate has not exercised the judicial discretion properly, and he should not have mechanically rejected the application. And accordingly, this court set aside the order of the London magistrate and allowed the prayer of the petitioner. In the case in hand, there is no dispute that the petitioner is a government doctor and she is a gynecologist. And during course of investigation, the investigating agency didn't think it proper for his arrest, for which notice under section 41 A CRPC was served on the appellant, and she abided by the terms and condition of the notice. The offences under which the charge sheet has been submitted are not serious offences, and the punishment prescribed for the offence under section 341 of the Indian Penal Code is simple imprisonment, which may extend to 1 month or with fine, which may extend to 500 rupees or with both. And punishment prescribed for offense under section 323 of the Indian Penal Code is for a term which may extend to 1 year or with fine, or which may extend to fine which may extend to 1,000 rupees or with both. So far as offense under section 32 BA, under which charge sheet has been submitted, it is stated that the offense shall be punishable with such punishment as specified under the Indian Penal Code for the offense, and shall also be liable with fine. In view of the nature of accusation against the petitioner, the age of the petitioner, the fact that she is a lady and a public servant, a doctor whose presence is very much necessary in the hospital, I'm of the view that the ground of rejection of the application under section 205 CRPC by impugned order dated so and so is not sustainable in the eye of law. Accordingly, the same is hereby set aside. The London Trial Court shall dispense with the personal appearance of the petitioner on giving an order taken by her to the satisfaction of the London Trial Court that the counsel on her behalf would be present in court throughout the proceeding, and that the petitioner shall have no objection in taking evidence in her absence, and further that she would attend the court as and when her personal attendance is required by the court. Accordingly, the CRLA is allowed.
अच्छा I may beg apology. Petitioner directly appellant खाली कहना है.
अच्छा appellant को.
I'm grateful. But may I pray for an urgent.
Yes, yes. Yes.
Lordship, item number 23.
I'm going pass over one by one.
Serial, Lordship, my lordship.
Pass over item number 9.
also tomorrow, and court personal appearance 22 also tomorrow, and 23 personal appearance court 23 data. Council is present.
Item 23.
Lordship, the notice and the CD were not sent. However, Lordship, I have inquired with the IAC. He had sent, in fact, on WhatsApp on 9/11/23, Your Lordship. However, no intimation was sent to the office. So, and the CD, he has stated it is there in a connected matter, but that file has been disposed of and our office is unable to arrange, obtain that file, Your Lordship. He's present on virtual mode, my Lordship.
Arun Kumar Singh.
Lordship.
IAC Jagannath Prasad.
My Lordship.
Yes. Since when you are posted as the IAC?
Sir, namaskar, sir.
IAC केबेठू जगन्नाथ प्रसाद पुलिस स्टेशन अछंती?
Sir, ମୁଁ 1 ସେପ୍ଟେମ୍ବର 2023 sir.
2021 सेप्टेम्बर रु आपण रहिलेनी?
नहीं sir, 2023 sir.
अच्छा, एई केस संक्रांत रे आपण को एजी ऑफिस रु केते थरो चिट्ठी गलानी जे केस डायरी पठेवा पई एवं इन्फॉर्मेंट को नोटिस सर्व करिकिनी कंफर्मेशन लेटर पठेवा पई?
सर ମୁଁ ଆସିଲା ପରେ sir ଗୋଟେ ଚିଠି ହେଇଥିଲା sir order
कौन कौन केबे पाइले से चिट्ठी?
ସେଇଟା sir 5/11 ପାଇଥିଲି sir.
केबे पाइले? 5/11?
sir.
कौन कले तापरे चिट्ठीटा पाई कौन कले?
ଚିଠିଟା ପାଇକି ମୁଁ ଆମର କମ୍ପ୍ଲେନାଣ୍ଟ ଯିଏ ସେ ହଉଛି ସଦର କୋର୍ଟ ସଦର ଥାନା ବାଲେଶ୍ୱର, ତାଙ୍କ ଆଇଏସି କୁ ମୁଁ ସାର୍ ଗୋଟେ ମେସେଜ କରିଥିଲି ସେ ନୋଟିସ ସର୍ଭ କରିବା ପାଇଁ, ତାପରେ ସେମାନେ ସର୍ଭ କଲା ପରେ ମତେ ସେଇ
केबे सर्व होला नोटिस?
ସର୍ଭ ହେଇଛି ସାର୍ ସେଇଟା 9/11/2023।
केस डायरी कोन पई पठेलेन?
केस डायरी सर सेटा गुटे आगु पठाइतला से कनेक्टेड रे सार को मु कहिथिली ता व्हाट्सएप रे सर डिटेल मु पठेइथिली सार को।
नै आपण यदि अन्य अन्य गुटे केस रे केस डायरी पठेइथिले एवं एजी ऑफिस को सेटा जणै दी थाते जे एई केस संक्रांत रे एई तारिख रे जाईची, आपण डी वेरीफाई कर दियंतु। आपण न जणैले केमती हबो?
सर सर मु सर पठे देबी सर, किंतु सार को मु मेसेज ऑलरेडी व्हाट्सएप रे करेइथिली कोड माने
Have you got the case diary now?
Me,
No.
Case diary in connected matter, it was there in 2 connected matters, but both the files we are unable to find out, Your Lordship.
So, case diary is not now available. So, you send another copy.
Sir.
And what about criminal antecedent?
Sir, mo verify kori ki sir sabung chon de.
Okay, the matter will come next Monday, that is 11th of December 23. So do the needful in the meantime. ଯେତେବେଳେ କୌଣସି ଇନଷ୍ଟ୍ରକ୍ସନ ପାଇଁ ଯିବ ଆପଣ ଇମିଡିଏଟଲି ରେସ୍ପଣ୍ଡ କରିବେ ଏବଂ ଯଦି ଅନ୍ୟ କୌଣସି କେସରେ କେସ୍ ଡାଏରୀ ଆସି ଯାଇଛି ସେ ବିଷୟରେ ମଧ୍ୟ ଜଣେଇ ଦେବେ ଯେ ଆପଣଙ୍କୁ ଏ କେସରେ ମୁଁ ଯାଇଛି, ଆପଣ ଟିକେ ଭେରିଫାଏ କରିଦିଅନ୍ତୁ, ଚୁପଚାପ ବସି ଯିବେନି। The Mr. Arun Kumar Singh, Inspector in charge of Jagannath Prasad Police Station, appears through virtual mode, and he submitted that notice on the informant has been made sufficient on 9/11/2023, and he has assured this court that he will send the case diary, so also instruction about the criminal antecedent, if any, against the appellant to the AG office by Friday, that is 8th of December 2023. In view of such submission, list this matter on 11th December 2023. Free copy of the order be handed over to the learned counsel for the state. So ଆପଣ 8 ତାରିଖ ଭିତରେ କେସ୍ ଡାଏରୀ ଆଉ କ୍ରିମିନାଲ ଆଣ୍ଟିସିଡେଣ୍ଟ ର ଇନଷ୍ଟ୍ରକ୍ସନ ଏ ଦିଟା ଯାକ ଏଜି ଅଫିସ କୁ ଜଣେଇବେ। କେସ୍ 11 ତାରିଖରେ ରହିଲା ଶୁଣାଣି ପାଇଁ।
sir followed sir.
Okay.
Sir no.
Pardon, my lord.
ये जो गुड़ाक सब 5 बाहर रहीनी, you bring it tomorrow. Hello? Including mention matter. Yes, call the matter.
Pardon to make a mention, my lord.
It's over. The list is
Item
over.
number 4.
Ata.
I beg to invite your lordship's kind attention to the evidence of PW3 returning officer. Paragraph 59 at page 127 and 128. Your lordship got it?
Yes, sir. ठीक है, 127. Yes.
Mine. I am aware that what are my duties and responsibilities as a returning officer as per the provisions mentioned under clause 6.2.1 under chapter 6 scrutiny, page 98 of exhibit 38, and accordingly I meticulously followed the same. I am aware about the provisions mentioned under clause 6.3.1 regarding persons to be admitted at the time of scrutiny under chapter 6 scrutiny, page 98 of exhibit 38, as well as section 36(1) of the RP Act 1951, and accordingly I meticulously followed the same. Pursuant to exhibit AF, I conducted scrutiny of all nomination papers of all the candidates on 5/4/2019, which commenced from 11 a.m. with the assistance of a team of officials. I also meticulously followed the provisions under clause 6.4.1 under chapter 6 scrutiny, page 99, exhibit 38, as well as section 36(1) of the RP Act 1951, and gave reasonable facilities for examining the nomination papers and the accompanying documents of all the candidates by all present at the time of scrutiny, and I also informed to all present to examine whether all the candidates furnished the requisite information in prescribed pro forma duly supported by affidavit. I am conscious about the presumption of validity of every nomination paper as mentioned under clause 6.7.1 under chapter 6 of scrutiny, page 99 to 100 of exhibit 38, and accordingly, I duly verified all the nomination papers filed by the respective candidates at the time of scrutiny. I gave opportunity to all the persons present at the time of scrutiny to examine the nomination papers of any candidate they like, raise objection, if any. In spite of giving such opportunity, no one raised any objection to the nomination papers filed by the respondent in any manner before me. On the date of scrutiny, I also examined whether the respondent was qualified and not disqualified to contest the election in question as per the provisions mentioned under Article 173, Article 191 of the Constitution of India and Part 2 of RP Act 1951. I also, Section 36, I also examined whether there has been a failure to comply with any of the provisions of 33 or Section 34 of the RP Act 1951 by the respondent, and I found no failure on the part of the respondent. I also examined and found that the signatures of the respondent and his respective proposers on all his 4 sets of nomination papers are genuine. During scrutiny of nominations, kindly pause here for a moment, my lord. I invite your lordship's kind attention to Section 36 of the RP Act. Your lordship got it? Mine. On the date fixed for scrutiny of nominations under Section 30, the candidates, their election agents, one proposer of each candidate, and one other person duly authorized in writing by each candidate, but no other person may attend at such time and place as the returning officer may appoint, and the returning officer shall give them all reasonable facilities for examining the nomination papers of all the candidates which have been delivered within the time and in the manner laid down under Section 33. Here he says on evidence in oath before your lordship that he has meticulously complied with this section, giving opportunity to all the present to examine the candidates and point out if there is any shortfall. I think your lordship had taken note of it.
Yes, sir.
Mine. Kindly come to subsection 2. The returning officer shall then examine the nomination papers and shall decide all objections which may be made to any nominations and may, either on such objections or on his own motion. Here the duty is twofold. Objection thile bhi karibe, objection nathile bhi on his own motion, he will examine. After such summary inquiry, if any, as he thinks necessary, reject any nomination on any of the following grounds. Grounds of rejection has been spelled out under the Act itself. A, that on the date fixed for the scrutiny of nominations, the candidate either is not qualified or is disqualified for being chosen to fill the seat under any of the following provisions that may be applicable. Here in the case 173, Article 173 and 191,
Yes.
is applicable to assembly and to MLAs. Whereas Article 82 and 102 is 84 and 102 is applicable to MPs, Parliament. Part 2 of this Act and Section 4 and 14 of Government of Union Territories Act 1963, or B, there has been a failure to comply with any of the provisions of Section 33 or Section 34, or C, that the signature of the candidate or the proposers on the nomination paper is not genuine. Kindly match it with the deposition. He has already deposed positively in favor of the respondent with respect to all these three aspects, subsections.
No, 34 it's all right about deposit that has been, but about that 33.
34 is deposit.
33(4) that comes within that power with the returning officer to ignore those. Okay. No, I put a question to you the other day that suppose there is something in that nomination paper, it is not in proper form. Let us assume one thing. The returning officer did not give any stress on importance on this end. He just said that it's okay and it cannot be a defect of substantial in nature. And also, nobody also raised any objection. But the court finds that whatever has been deleted, okay, from the nomination paper are relevant and should have been mentioned. Even if the returning officer says so, even if there is no objection, whether if the court finds that what has been deleted is very material and it should not have been deleted, whether the court can come to the finding that the acceptance of the nomination paper in such form is illegal or not?
Certainly, yes.
Yes.
If the court finds.
Yes.
Number one. And also the court has to come to a conclusion that the defect pointed out or deletion made is not a defect of substantial character.
Yeah.
Both the ways.
No, if it is of substantial character and it has been ignored,
then court can find.
Right.
Yes.
That is good. So that means if we say in sum up that merely because no objection was raised.
No, that cannot be done. Court has ample power within the act to come to a different conclusion or a finding than that has been arrived at by the returning officer.
Okay. Now,
but that has to be not a subjective satisfaction.
Okay.
That has to be dependent upon the objective satisfaction.
Okay. Now, I again put to or repeat that question which I had put to on the last day, that 33(4) deals with the power of the returning officer as to what he can overlook.
Yes, Major.
That has been mentioned that any misnomer, inaccurate description, clerical, technical, and printing error
minor
in the electoral roll or in the nomination paper.
Minor.
Here we are concerned with the nomination paper.
Minor.
So misnomer, one thing, inaccurate description, 2, clerical, 3, technical, 4, printing error, 5.
Minor.
These are the 5 things the returning officer can overlook it.
Minor.
If it is now, if the returning officer says that this deletion comes within this.
Yes.
But the court, after analyzing the law or whatever it may be, finds that no, this should not come. This deletion would not come within any of these 5.
Yes.
Okay.
Court can record its finding other way.
Then the court can also arrive at a conclusion that the acceptance of the nomination paper, overlooking this aspect on the ground that it comes within this 5 was not justified, was not proper.
Yes.
So your witness, their witness, of course, says that these are the 5 circumstances, and according to me, this deletion comes within any of these. Obviously, what is a misnomer, what is an inaccurate description, clerical, technical, printing error, that has not been enumerated in detail
Defined or
either,
enumerated under
right?
the Act.
So if it is not defined, then in plain and general meaning, as per the dictionary meaning, it is to be seen. So it is to be seen whether a deletion of a part of the nomination paper comes within this part. That means the court has got the power,
Yes,
in spite of the evidence of the PW3, the returning officer. Court can appreciate the same, court can apply the mind, and court can see whether the evidence is acceptable or not. Okay.
The court, while exercising this jurisdiction, has to read 33.4 in conjunction with 36.4. 33.4 has your lordship read? Now kindly
substantial character again.
ଦିଟା ଜାଗାକୁ ଦେଖିକିରି ଆପଣ କରିବେ. Beyond this, no statutory power has been given to the court to reject the nomination. Subject to what will be addressed to before your lordship by my
But let us, that means what you want to say, that let us, even if the court comes to a finding that this deletion does not come within any of these 5 as per 33.4, but still then, even if it is a defect, but it is not of a substantial character, then also the whatever has been done by the returning officer cannot be said to be illegal. Or okay, all right.
Then
just a minute. Yes.
Kindly take a further note here. Your lordship has put a material question. The court has also to come to a conclusion and record a finding that the part deleted by respondent is relevant for him and is applicable to be him, applicable for him to be filled up, to be filed by him.
Yes.
Kindly note my further submission here that I say that part 2 of Form 2B is neither applicable to the respondent.
That is already there. It is not applicable.
It is not applicable there.
They are not disputing that. They are not disputing that that particular part is not applicable to there. There is no dispute. Not only there is no dispute, but also their witness, that means PW3 has
He also said it is not relevant.
It is not relevant.
And under part 2 of the nomination paper, the respondent as a party set up by a recognized national political party, as a candidate set up by a national political party, is required to furnish some information, and he has not furnished some.
Yes.
It will take a kind of note. This also relates to not only part 2, but also part 3 as well as part 3A. Good.
Yes.
Kindly come to page 128.
Yes, I was going.
9th line from top. I also.
Hmm.
Your Lordship got it?
Yes.
My Lord. I also examined whether there has been a failure to comply with any of the provisions of section 33 or section 34 of the RP Act by the respondent, and I found no failure on the part of the respondent. I also examined and found that the signatures of the respondent and his respective proposers on all his 4 sets of nomination papers are genuine. During scrutiny of nominations, after due verification and scrutiny of all the 4 sets of nomination papers and the accompanying documents filed by the respondent on 2/4/2019 and 4/4/2019, I found that there was no defect of a substantial character in the same, for which I accepted all 4 sets of nomination papers of the respondent as valid.
That is 36.4.
My Lord, 36.4.
Yeah.
I have gone through the provisions under clause 6.9.1 to 6.9.6 and clause 6.10.1 to 6.10.3 HBR. Under chapter 6 scrutiny, page 100 to 103 of exhibit 38, and I meticulously followed such provisions while examining the nomination papers of the respondent as well as other candidates during scrutiny of nominations. These clauses, my Lord, refers the grounds for rejection. 6.9 is not to reject. 6.10 is ground to reject. Then kindly come paragraph 61 at page 128 and 129. This is important. The averments taken in paragraph 7a at page 7, 10th line from the bottom, in the election petition to the effect, it was incumbent upon the returning officer to reject the nomination papers of the respondent, but the returning officer illegally and improperly accept the nomination papers filed by the respondent in contravention of section 33 of the RP Act 1951, read with Rule 4 of the Conduct of Election Rules 1961, and further pleading that the returning officer should have rejected the nomination paper of the respondent while exercising power under section 36 of the RP Act 1951 at the time of scrutiny, as the nomination papers filed by the respondent was not in prescribed form to be, are not correct. This suggestion was given and she emphatically denied it. And despite that, I have been consistently submitting before your lordship that despite that, they did not file application before your lordship to declare him hostile, nor made any prayer before your lordship to cross-examine him.
No. A witness for one party will support the other party to such an extent it is never seen.
Never cannot be thought of. Therefore, my submission before your lordship, though he has been called as a witness on behalf of the election petitioner, he has a statutory duty to state the law before your lordship and assist your lordship to determine the issues. Because he is more bound by the provisions of the Constitution as well as Representation of People Act.
Yes.
Then alliance to your lordship.
Yes.
अब से डॉक्यूमेंट भी देखी करी अपन को उत्तर देची गोटी गोटी. Now, I will close my submission with respect to the evidence of PW3. Now I will invite your lordship's kind attention to the evidence of election petitioner himself.
You are now focusing your argument about those parts which has been deleted, right? It's not the other part, criminal, etc.
No.
Separate thing.
I am only on 7A.
Right.
When I will come to 7B also, I will.
Okay. Yes, which paragraph?
Kindly check.
Evidence on affidavit or non-number paragraph, page 5.
Page 5. Yes, Kim.
That the respondent Muhammad Mokim filed his nomination as a Indian National Congress INC candidate.
No. Ticket.
Evidence on affidavit.
Evidence on affidavit. Eta kon bar karo?
ମୁଁ क्रॉस एग्जामिनेशन को जाइनी.
Exhibit 36 बोली मार्क करा.
Evidence टा bar कर दो.
Exhibit 36 बोली मार्क करा दी.
प्लीडिंग टा बार करता. प्लीडिंग टा शेर की रिपीट करती.
Evidence on affidavit by Devasi Samudra.
Mind.
Who paragraph ta पूछेंगे?
Page 5 paragraph 9 में.
Page 5 paragraph 9. That the respondent.
That the respondent Muhammad Mokim filed his nomination as Indian National Congress INC candidate for 90 Baravati Kotak Assembly constituency before the returning officer on 2/4/2019, but the same was not in prescribed form 2B. The respondent suo motu deleted part 2 of the form 2B in the nomination papers filed by him before the officer on 2/4/2019. The part 3 of form 2B of the nomination paper filed with the respondent are also not in the prescribed form 2B. Part 3A of the nomination paper filed by the respondent have not been filled up by the respondent. The columns of part 3A of the nomination papers have been left blank, and columns 3 to 9 are also not in the prescribed form 2B. The respondent has filed his nomination papers prepared by himself and has not filed the same in form 2B obtained from the office of the returning officer of 90 Baravati Kotak Assembly constituency. Kindly note this last sentence I pressed. This was beyond pleading, this particular sentence. And so far as the other pleading statements are concerned in the evidence on affidavit, kindly compare it with paragraph 7A. It is verbatim reproduction of his statement.
This is evidence on affidavit.
Evidence on affidavit का मैं कहली paragraph
9. Exhibit 36. Exhibit 36. Paragraph 9. At page 5. At page 5. Aberments in paragraph number 9. Right?
Minor.
compare करा जो
last sentence paragraph the respondent has filed his nomination papers prepared by himself and has not filed the same in form 2B obtained from the office of returning officer of 90 Baravati Kotak Assembly constituency. This sentence is beyond pleading.
Has not filed. Is 6 row.
Page 6 row last line.
Top line.
Page 5 row last line. Continue to page 6 row.
Top.
Beyond pleading.
Beyond pleading.
And other pleadings in page 5. With respect to part 2, part 3, and part 3A, are exact verbatim reproduction of
election petition.
ସେଇଠି ମାଇନ୍ ଲର୍ଡ ଦେଖିବେ
just
note
verbatim election petition.
ସେଠି ବି ସେ କହିଲେନି how it is not in prescribed form.
How it is not there. How it is not in prescribed form.
ସାକ୍ଷୀରେ ମଧ୍ୟ ସେ ଜଣେଇଲେନି ଆପଣଙ୍କୁ ଯେ କେମିତି ଏଟା ପ୍ରେସ୍କ୍ରାଇବ୍ ଫର୍ମରେ ନୁହେଁ। ଏବଂ ମାଇନ୍ ଲର୍ଡ ଦେଖିବେ ତାଙ୍କର exhibit 1, 2, 3, 4 those copies were filed by the on behalf of the
let us begin one by one. First as he कहले the respondent so motu deleted gala the part 3 of form 2B of the nomination paper filed by the respondent are also not in prescribed form 2B. ei jota je कहउचंदी
papers reading paper
you mean to say that he should have also mentioned that in what way it is not in khali this aberment is not sufficient. Okay.
And alternatively, at one place he refers to paper, singular one.
In election petition.
ତାହେଲେ ଗୋଟିଏ ନମିନେସନ ରେ ଭୁଲଟା ଅଛି ବୋଲି ସେ କହୁଛନ୍ତି
ଯୋଉଟା କି ଏଠି କହୁଛନ୍ତି ପେପର
ଏଠି କହୁଛନ୍ତି papers
ସେଠି paper and is ଅଛି ଏଠି papers and are ଅଛି
okay
ତା ବାଦ ଆଉ କେମିତି ପ୍ରେସ୍କ୍ରାଇବ୍ ଫର୍ମ ରେ ନୁହେଁ ସେ କୋର୍ସ କିଛି
ସେଟା ନୋଟ କଲେ
okay
and part 3 ଉପରେ 3A ଉପରେ ମାଇନ୍ ଲର୍ଡ ଯୋଉଠି କହୁଛନ୍ତି page 5 ରେ
not been filled up by the respondent.
Again they have filed those documents on माइनर के नोट करंतु 29/6/2022 रे Exhibit 1, 2, 3, and 4, and Exhibit 32 to 35. They have filed earlier before commencement of the examination evidence of PW1, and they marked exhibit. And those documents were marked exhibit on 18/11/2022. Exhibit 1, 2, 3, 4.
नहीं कौन है पार्ट 3 एटा कौन है जी अपन से कोजने अपन पार्ट 3 ऑफ द नॉमिनेशन पेपर हैव नॉट बीन फिल्ड माने टोटली फिल्ड अप इन बोली हां
एग्जिबिट करि छाला परे मध्य
से निजे एग्जिबिट करचंती वेयर इट इज अवेलेबल दैट इट इज फिल्ड अप
Exhibit 1, 2, 3, 4.
It's all right. It is filled up.
It's filled up.
Okay.
Have been exhibited on 18/11/2022.
Just a minute. Part 3A of nomination paper not been filled up.
Filled up.
Whereas this
and second sentence.
Say exhibit ta टिके हजूर देखि दिया.
तापर second sentence note कर दियंतु. The columns of part 3 of the nomination papers have been left blank.
Columns of Swansu
3A.
Columns 3A. 3A not filled up or blank तो मानने से या हो.
And columns from 3 to 9 are also not in the prescribed form 2B.
3 to 9 not in prescribed form. कौन क्वेश्चन देखियो अपन दो.
देखि दियो.
कितने नंबर सेड़ा क्वेश्चन.
1, 2, 3 पर अपन list of exhibits का देख लीजिए.
एक गोटे
ये लिस्ट ऑफ एग्जिबिट्स का देख लेना जाना पड़ेगा ना. एग्जिबिट टा को देखिए.
एग्जिबिट को देखो. कितने नंबर एग्जिबिट देखिए.
3, 4 my lord.
एग्जिबिट 1 टावर. हाँ ऑल राइट एग्जिबिट 1 पार्ट 3 एटा केते नंबर पेज रे अछि
सेटा खाली देखंतु डेट ऑफ प्रोडक्शन प्रोड्यूस्ड बाय इलेक्शन पिटिशनर 29/6/2022 से कोर्ट रे दाखल कले 29/6/2022 रे एवं एग्जिबिट मार्क कले ताको 18/11/2022 आफ्टर inspection of the documents as directed by the honorable court 29/6/2022 रे से प्रोडक्शन कले प्रोड्यूस कले 18/11/2022 रे 1, 2, 3, 4 पे एग्जिबिट मार्क कले एवं एठी एविडेंस ऑन एफिडेविट फाइल कले माय लॉर्ड ऑन पांच 1/2021 से ओथ नहीं चल 5/1/2023
when after verification in spite of that he is mentioning
he again says falsehood before this honorable court
no part 3 को असम
part
3 से कहउजंदी ता गवर्नमेंट होची part 3 एटा कहउजंदी
is not in prescribed form.
नहीं part कहउजन not
have not been filled up
part 3A part 3 एटा देखियो
3A टा not filled up.
part 3 एटा हां से नो लिखि जंदी एन लिखाई छी अच्छा
ऐसे जो 2 रु न
नहीं एक 2 तो फील्ड ऑफ है जी 3 नो लिखाई छी हां 4 नो लिखाई
खबरदार नेक्स्ट पेज में लॉर्ड
हां
7 लिखाई छी 8 लिखाई छी 9 भी लिखाई
ये तो सब अच्छी okay this is 3A exhibit 1 shows okay exhibit 1 shows part 3A has been filled up. I would have 3 to 9 not in prescribed form.
3 to 9 कहउछन but 9 is in prescribed form.
9 टा whether अच्छा और से जो 3 to 8 भीतरे यदि आंसर टा yes ही थांदा ताले सेकंड सेंटेंस टा
से क्लैरिटी करनांती कि डिस्क्राइब करनांती इन एविडेंस ना
अच्छा जे जो माने एथरे करनांती हम सिंपल लेचंती
not specific
not a ठीक अछि
not a ठीक अछि
okay continue
समती exhibit 32 to 35 में लो जो तरह से
no I will verify because गोटे सैंपल तो देखिलु हमने तो yes Mr. Mishra
now
you are pressing that
paragraph 9
Paragraph 9 of evidence affidavit. Yes.
Then
ଆପଣ page 6 ପର୍ଯ୍ୟନ୍ତ ଆସିଥିଲେ ତାର।
ଆଜ୍ଞା ଆଜ୍ଞା।
ହଁ।
Thus, it was necessary for the returning officer to reject the nomination papers of the respondent, but the returning officer illegally and improperly accepted the nomination papers of the respondent. The returning officer should have rejected the nomination of the respondent at the time of scrutiny, as the nomination papers filed by the respondent was not in prescribed form 2B. The illegal and improper acceptance of nomination papers of the respondent has materially affected the result of the election so far as it concerns the returned candidate. As such, the same is liable to be set aside. I will request your lordship to pause here for a moment. This is an essential and vital pleading. Result of election has been materially affected. This statement in the plaint has been repeated here. There should be at least one of the voters should have been cited as a witness to come to the dock and tell before your lordship on oath that yes, if all these matters should have been done, then the result would have been otherwise. Respondent Mohammad Mokim would have got 20,000 less votes. Devashish Samantarai, BJD, would have got 20,000 more votes. गोटिए भी साक्षी से देइनांती. So far as who would have been affected by this? Only the voters. Where is the evidence of a voter? No, 33. Correct.
Yes.
Then my lord may kindly come to page 25, paragraph.
Exhibit 36.
So exhibit 36 ro paragraph 33.
Page केते कहले 25.
25.
25 यानी ए जोटा एविडेंस एफिडेविट में
आगे
डिपोजिशन 35 का
33.
33
page 25.
Yes.
That the non-filing of nomination papers in the prescribed statutory form 2B and whatever has been filed with blank particulars materially affects the result of the election. As such, the election of the respondent declaring him as MLA of 90 Baravati Assembly constituency is to be declared void and is to be set aside.
Yes. Non-filing of nomination papers in the prescribed and whatever has been
all nomination paper blank
has filed with blank particulars matter. Yes.
Then
कितने पेज?
Examination in chief question. PW1.
पेज कितने कौन?
Yes, my lord. 8. Examination in chief of PW1.
पेज 8 तो
आगे
एविडेंस एफिडेविट
नहीं आगे एग्जामिनेशन इन चीफ जेतले आपण डिक्टेशन नेले
अच्छा ସେଇଟା ଆଚ୍ଛା page 5 ହଁ page 5
नहीं पेज 8 में था।
page 8 ହଁ ଆରମ୍ଭ ହେଇଛି paragraph 44 ଅଛି
Minor,
ହଁ
I downloaded the nomination papers and affidavit filed by the respondent from the web portals as mentioned in paragraph number 12 of my evidence affidavit. After the result of the election of 90 Baravati Kotak Assembly constituency of the year 2019 was declared, which was around 2 months of the election. Your Lordship got it?
Yeah.
Neither. In the evidence affidavit in paragraph 4, I have mentioned that the election was held on 23/4/2019. The declaration of result was made on 23/5/2019. ମାସକ ପରେ I downloaded the nomination papers and affidavits filed by the respondent as already stated. Within 15 days of declaration of result, 23/5 15 दिन ଭିତରେ ମାନେ around June first week ଭିତରେ second week ଭିତରେ within 15 days of the declaration of result of election, I downloaded the nomination papers and affidavits by the respondent as already stated. Those downloaded copies have been filed by me, which have been already marked as Exhibit 1 to 4, Exhibit 32 to 35. Kindly take a pause here. ସେ କହୁଛନ୍ତି ଏଇ ଜୁନ ମାସରେ 2019 Exhibit 1 to 4 ଆଉ Exhibit 32 to 35 के डाउनलोड करथिले. Where is those documents? As per Exhibit 1, I have downloaded it from the web portal of Election Commission of India on 28/6/22. এটা 3 ବର୍ଷ ପରର କଥା. At 5:11 p.m. Exhibit 2 was downloaded from the web portal of Election Commission of India 28/6/2022 at 5:32 p.m. Exhibit 3 was downloaded from the web portal of Election Commission of India on 28/6/2022 at 5:25 p.m. Exhibit 4 was downloaded from the web portal of Election Commission of India on 28/6/2022 at 5:19 p.m. Kindly come to the next paragraph. At page 9. As per Exhibit 32, certificate under 65B Indian Evidence Act was issued by one Dipankar Acharya on 18/11/2022 and nomination paper at serial number 2 dated 2/4/2019 along with the affidavit in form 26 of the respondent was downloaded on 16/11/2022 at 9:58 a.m. ଆହୁରି 5 ମାସ ଗଡ଼ିଗଲା. ତାପରେ as per Exhibit 33, the certificate under Section 65B of the Evidence Act was issued by Dipankar Acharya on 18/11/2022 and the nomination paper serial number 3 dated 2/4/2019 along with the affidavit in form 26. The respondent was downloaded on 16/11/22 at 9:57 a.m. As per Exhibit 34, the certificate under Exhibit 65B of Indian Evidence Act was issued by one Dipankar Acharya on 18/11/22 and the nomination paper serial number 4 dated 2/4/2019 along with affidavit in form 26 of the respondent was downloaded on 16/11/2022 at 9:55 p.m. as per Exhibit 35. The certificate under Section 65B of Indian Evidence Act was issued by Dipankara Acharya on 18/11/2022, and the nomination paper serial number 5 dated 2/4/2019 along with affidavit in Form 26 of the respondent was downloaded on 16/11/2022 at 9:53 a.m.
So that means if these evidence is to be accepted, then these documents were not available with him when the drafting of the election petition was done.
In
Even
paragraph 44,
uh,
the witness says, those downloaded copies have been filed by me, which have been already marked as Exhibit 1 to
ମୁଁ
court.
ଦେଖି ସାରିଲିଣି ସେ ଯଦିଓ ସେ କହୁଛି ଯେ those downloaded copies have been filed because the date of download is June 22.
22.
So, and the election petition was filed in 1999. Right. And even the evidence affidavit was filed in, I think, what is the date when the
এটা 5/1/2023
Acha, evidence affidavit बेलू थिला था. Okay.
Kindly note, no evidence in examination in chief to substantiate the allegations that how the nomination paper form 2B are not in the prescribed form 2B and what are the departures from the prescribed form which comes under a defect of a substantial character and whether it was relevant and applicable to the respondent.
No.
Evidence on
the-
affidavit
since they have stated that on the basis of downloaded copies, the government's the election petition was prepared. Let us say
that was not exhibited.
That very document because
on the basis
that would have been the best document to persuade your lordship's judicial conscience that what the election petitioner states is at least correct.
You quoted the 3A and left blank, but we see that 3A has been filled up. So maybe that if you say that when that was the past document.
କରିଥିଲ ସେଇଟା ହୁଏତ blank ଥାଇପାରେ. Why did not you exhibit it? ଏଟା ଟିକେ kindly note କର. ସେ note କର. Yes. ନାହିଁ ବାବୁ ଗୋଟେ note କରିଛି. ସେମିତି ହେଲେ କୋଉଠି irritate
after 2022 and therefore declaration election petition So, Mr. Mishra, whatever original election nomination paper, downloaded copies, all those are available before the court now. And if we find that, in fact, this averment which has been taken, that 3A has been left blank, it is not correct, because in those
In reality,
documents, it is there that has been filled up. Maybe a part is they are not, but it is not left blank. Then obviously it can be said that a false statement has been made.
Okay, paragraph 33 of the evidence on affidavit se କହୁଛନ୍ତି କି whatever has been filed with blank particulars.
That has been taken
I have
note of.
noted.
33 ରେ ସେ କହିଛନ୍ତି ଏମିତି ମାନେ part
Noted.
1, 2,
I
3.
have noted.
Right.
So, resort to falsehood by stating that 3A has been left blank. Yes.
I will go to the cross-examination part tomorrow.
Yes. Think about.
Need my help. At 3, my lord.
3.